In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Without any fanfare or ceremony, Senator Sam Ervin today sounded the closing gavel on the first phase of public Senate hearings that have made history. After 35 witnesses in 37 days of testimony, adding up to more than 1.5 million words, the Watergate hearings have surpassed even the Army McCarthy hearings of 1954 as a televised event. The committee has not yet finished with Watergate. It'll come back in September and hear 6 more witnesses before moving on to Phase 2, an investigation of campaign funding, and Phase 3, dirty tricks. The interval now will give President Nixon time to deliver his much-anticipated rebuttal to the damaging testimony of many witnesses here. For its finale today, the committee had 2 strong personalities as witnesses, former Attorney General Richard Kleindienst and Assistant Attorney General Henry Peterson. These 2 men, who had official charge of the Watergate investigation, resolutely defended the thoroughness of that investigation and the political independence of the Justice Department. And Peterson, criticizing the appointment of Special Prosecutor Cox, said the Justice Department would have cracked the Watergate case if it had not been snatched away.
After tonight, it's over, for a while at least, and the basic question is still the one that was asked the first week and during each succeeding one. With all this conflicting evidence from the many witnesses with their varying good guy, bad guy impressions, manners, and axes to grind, who are we to believe? Or to put it crudely, who's lying and who's telling the truth, and how do we go about making that decision? Well, Peter Kay discussed this general subject with Committee Vice Chairman Howard Baker at the close of it all today, couched in terms of what he has learned thus far.
Do you really feel we're any closer to knowing the central questions after all of this testimony and evidence and documents and some tapes of who planned it, who carried it out, and who covered it up? Do you feel any more satisfied about that?
We know a great deal more than we did before, but we don't know with absolute certainty who did what, when, and where the responsibilities lie. We don't know, for instance, what the president knew and when he knew it. We have much, much more information on that subject, but most of it's tangential and circumstantial.
How are we ever going to find out?
Well, you see, there's not a requirement that this committee find the truth. That is simply our ambition. There's no statute that says we have to establish the facts beyond a reasonable doubt, although that would be highly desirable. The mandate to this committee is do the very best you can from all of the facts and circumstances that are available, digest it and report it to the Senate. The tapes, the presidential tapes, the access to documents, and all the rest, the things that might yield information in that respect in furtherance of our search, will inevitably affect the quality of our report. But no matter how the litigation turns out, no matter what the Supreme Court may say about our access to documentation and presidential tapes, we will state our conclusions. And they, no doubt, will be weighed and judged not only by the Senate but the country. But the answer to your question is we have a great volume of additional information, and it does serve as the basis for an intelligent judgment of what happened. But we may never be completely certain.
Richard Kleindienst and Henry Peterson were the 2 witnesses today on this, the 37th day of these hearings. Hugh Sidey, Washington Bureau Chief and columnist for Time Magazine, watched them in action with us. Hugh, what advance or guiding comments would you offer about these 2 men?
Well, I must say these were 2 very human persons, and they were a delight to watch. It wasn't a bore at all, this last chapter. As a matter of fact, Kleindienst came on. He had the face, the tone, the manner of a cop. He had an engaging smile. He was tough, and yet he had some emotion in him. And we got the sights and sounds of the locker room out at Burning Tree, as well as some honest-to-goodness anger at John Ehrlichman. Mr. Peterson, on the other hand, would look like a dead honest attorney general, big craggy face. He described the Byzantine atmosphere of the White House, and he too showed emotions, outrage, hurt, all of these things. I think by and large, they were two excellent witnesses for themselves.
Okay, there was also significant Watergate activity in Judge Sirica's courtroom downtown today. And Jack Murphy at the Georgetown University Law Center, who, as you regular viewers know, has been with us many times as our legal expert, went down there. Jack, first of all, tell us what happened, and then tell us what it all means.
Jim, this was the day they had the hearing on the July 26th show cause order, which the district court had issued several weeks back. Question was, does the president have to respond to the subpoena? And today the president came in and filed what he called a special appearance, not a motion to quash. Apparently is not prepared to go along with the usual court processes. And in this special appearance, he asked the court to vacate that order to show cause, saying that executive privilege prevented the court from enforcing an order against the presidential branch under the separation of powers doctrine. He argued that the character of the presidency would be fundamentally altered if a different rule applied, and that the notion that the president could be held personally subject to orders of the court would radically change the status of that branch as a coordinate and equal branch of government. He didn't say that there was no power to issue the subpoena. He said there was no power to enforce it. This is the intriguing question.
All right, now what happens next?
On August 22nd, we'll have oral argument on this after Mr. Cox has responded to these papers filed today. He will file his response next week, and in about 15 days we'll hear the argument. Now, what will happen after that is wholly speculative. We have no idea.
All right, and also it needs to be pointed out that the committee has deferred action on what it's going to do as far as its potential legal action involving the tapes until this whole matter is resolved involving Archibald Cox, right?
Yes.
Okay, Hugh Sidey and Jack Murphy will be back at the close of tonight's broadcast to talk about this, the final day of the first phase of the Watergate hearings in more detail.
To help you plan your evening's viewing, here is NPAC's hour-by-hour look at today's testimony. In the first hour, Kleindienst describes his reaction when he was visited at the Burning Tree Country Club by G. Gordon Liddy and first told of the Watergate break-in. He praises Ellsberg's trial judge Matthew Byrne and tells of his own feelings about the burglarizing of Ellsberg's psychiatrist's office. In the second hour, Senator Baker explores exactly what happened when Kleindienst told the president about the involvement of White House and re-election committee staff members in Watergate. And Kleindienst strikes a positive note with a list of the triumphs for the press and for the congressional system that have emerged from the case. In the third hour, when Kleindienst concludes his testimony, he's pressed by Senator Weicker on the circumstances of his resignation. Kleindienst says he'd wanted to announce it himself, that the president wanted to announce it along with the resignations of Haldeman, Ehrlichman, and the firing of John Dean. In the fourth hour, Assistant Attorney General Henry Peterson is the witness. He describes what was said in several meetings he had with President Nixon, including a critical one when he outlined the Watergate involvement of Dean, Ehrlichman, and Haldeman. During the fifth hour, Peterson makes a spirited defense of the Justice Department's Watergate investigation and disparages the need for a special prosecutor. Peterson also describes his suspicions of a possible cover-up in the case, saying his feelings at the time were, nobody acts innocent. And in the final hour of the day and of this phase of the hearings, Peterson says he never got any special orders from the president to investigate and report on the case, as Mr. Nixon claimed in an April statement. Senator Weicker wonders who did get such orders. And Peterson also defends the president's right to record his conversations for history. Now to Senator Ervin and the final day's hearing.
The committee will come to order. The committee met in executive session this morning and decided to postpone filing the suit until counsel for the committee have an opportunity to ascertain and study the reaction of the White House attorneys to the motion of special prosecutor. I'd like to put in the record a statement of the American Nurses Association setting out the code of the nurses in respect to their attitude towards revealing confidential information they acquire while serving the patients. The counsel will call the first witness and
Former Attorney General Richard Kleindienst.
Mr. Kleindienst, will you stand up and hold up your right hand?
Yes, sir.
Do you swear that the evidence that you shall give to the Senate Select Committee on presidential campaign activities shall be the truth, the whole truth, and nothing but the truth, so help you God? Now, you might identify yourself for the purpose of the record, giving your name and address.
Mr. Chairman, my name is Richard G. Kleindienst. My address is 8464 Portland Place, McLean, Virginia. I do not have a prepared statement, Mr. Chairman. I'm here voluntarily to provide to you, the members of the committee and the council, whatever information that I have and which you deem to be relevant to your investigation.
Mr. Chairman, Mr. David Dorson, Assistant Chief Counsel, will open the questions.
Mr. Kleindienst, am I correct that you are presently engaged in the private practice of law?
Yes, sir. After I left the Department of Justice, I opened up an office in Washington, D.C., and I'm a private practitioner by myself.
And you resigned as Attorney General as of April 30th, 1973?
I believe that it was April 30th, yes, sir, effective upon the qualification and appointment of my successor.
Mr. Kleindienst, could you please summarize for us briefly your background, especially with respect to your positions with the United States government?
I've only had two positions with the United States government. That was the position of Deputy Attorney General of the United States, a position that I believe that I was commenced around the 1st of February 1969. And the other position that I've had with the United States government is the Attorney General of the United States, a position that I commenced on or about June 8th of 1972.
Mr. Kleindienst, when for the first time did you learn that there was electronic surveillance of the Democratic National Committee headquarters at the Watergate?
Well, I learned it for the first time after June 17th, when the individuals who were arrested at the headquarters were arrested. I don't know whether I learned of the electronic surveillance on Saturday, June 17th, or sometime the early part of the next week.
But on June 17th, you were notified of the fact that there had been a break-in?
At approximately 8 o'clock in the morning, Assistant Attorney General Henry Peterson of the Criminal Division of the Department of Justice called me at my home and indicated to me that there had been a break-in at the Democratic National Headquarters at the Watergate Hotel. All the information that he had at that time was that there was a break-in, and I believe he said to me, it looks like it might have been a bombing case. The next knowledge of any kind that I had with respect to it came approximately 3.5 hours after that, when I met with Mr. Gordon Liddy and Mr. Powell Moore in a section of lockers at the Burning Tree Club, which is a golf club in Washington, D.C.
How did that come about, Mr. Kleindienst?
The reason why I was at the Burning Tree Club, they had their annual member guest golf tournament, of which I was a participant. I think I was scheduled to tee off for the Saturday round afternoon. I was having lunch in the main dining room area of the Burning Tree Club. I looked up and Mr. Gordon Liddy, who I recognized, came in with Mr. Powell Moore, and I likewise recognized him.
Who is Mr. Powell Moore?
Mr. Powell Moore was the Deputy Public Information Officer of the Department of Justice when I was there as the Deputy Attorney General. When Mr. Mitchell resigned as Attorney General and went over to the campaign committee for the re-election of the President, Mr. Powell Moore went with him to the campaign committee. I do not know what his title was at the campaign committee, but I knew Powell Moore quite well as a result of our association together at the Department of Justice.
I believe you indicated that you recognized Gordon Liddy. What was the circumstances under which you first met or got to know Mr. Liddy?
The only association I ever had with Mr. Liddy, except for this particular meeting on Saturday, June 17th, was in the year 1969, when I headed on behalf of the executive branch a task force that was looking into and devising a program of action with respect to the marijuana traffic from the country of Mexico into the United States. I believe that Mr. Liddy at that time was an officer or employed by the Treasury Department, and he was one of the representatives from the Treasury Department in that task force. There were representatives from 6 or 7 departments of the government. That would have been in the late spring of 1969 and the summer of 1969. To the best of my recollection, I never saw Gordon Liddy after that time in the intervening years until that Saturday morning on June 17th, and I have not seen him since.
What was the nature of the experience that the Justice Department had with Mr. Liddy in connection with his role in Operation Intercept?
Well, I had no experience with him because he was under the jurisdiction of the Secretary of the Treasury. He had one assignment, as I recall, with respect to going from town to town along the United States-Mexican border to inform the business community who were quite concerned about so-called Operation Intercept. My recollection, which is not very precise, is that the manner in which Mr. Liddy was giving information with respect to our program was unsatisfactory, and I believe that based upon the information that I got, I recommended to the Secretary of the Treasury or Mr. Rosides, who was, I think, his immediate superior, that Mr. Liddy be called back from that assignment and not to continue any further with it.
Do you have any other recollection about any possible problems with Mr. Liddy or why his performance was considered unsatisfactory?
No, sir.
Directing your attention to the locker room of the Burning Tree Country Club, what happened when you saw Mr. Moore and Mr. Liddy there?
The first thing that I remember with some preciseness is the fact that Mr. Liddy, when he came into the entranceway of the dining area and saw me, in a rather furtive manner, made a motion to me like this, indicating, "Come here." I got up out of my chair and went over there. He was very agitated and seemed to be quite upset. He said that I have to talk to you in private. Where I was standing was not a very private place. There must have been 60 or 70 men who were eating or standing around. Right to the left of where he was, there was a little locker room complex at the club. I looked in there and no one was in there, so I said, "Gentlemen, come in here. I think this would be a private place to talk." We went in there. Mr. Liddy said that I've been asked to come out and give you a report with respect to the Watergate break-in last night, or the break-in of the Democratic National Committee. I don't know which he said. He said to me that he believed that some of the persons who were arrested might be employed by either the White House or the campaign committee for the re-election of the president. My reaction to that statement was instantaneous and rather abrupt. I think he also said, although I don't have too precise a recollection of it, that Mr. Mitchell had asked him to come out and talk to me. That was incredible to me. The relationship I had with Mr. Mitchell was such that I don't believe that he would have sent a person like Gordon Liddy to come out and talk to me about anything. He knew where he could find me 24 hours a day. In any event, as a result of my surprise, my incredulity, and I think my instant realization of the implications of what he had just said, prompted me to pick up the telephone and locate Mr. Henry Peterson. That I was able to do very quickly. All I had to do was to call the Justice Department switchboard and have her call him at home and put him on the phone. since Mr. Peterson had called me at 8 o'clock, I didn't have to explain much to Henry. I told him, and I've always been of the impression that I said to Mr. Peterson that Mr. Gordon Liddy of the campaign committee is here. Mr. Peterson, based upon a conversation I've had with him, does not remember my mentioning Mr. Liddy's name. But in any event, I was intent upon giving him a very specific, direct instruction right then that with respect to those who are arrested at the Watergate, they should be given no treatment that would be different than anybody else who might have been arrested in circumstances of that kind. I was quite upset. To the best of my recollection, the next thing I did was to turn to Mr. Liddy and tell him to leave the premises, because I know immediately thereafter Mr. Moore and Mr. Liddy left.
Mr. Kleindienst, aside from the conversation you had with Mr. Peterson, which you just described, to whom else did you recount the incident at Burning Tree?
I might have told Mr. Dean. I don't recollect doing so. I have no recollection of recounting this incident to anyone else until I was interrogated by personnel from the Select Committee and also personnel from Special Prosecutor Cox's staff.
You are aware, are you not, that Mr. Dean has testified with respect to reported conversation you had with him on the subject?
I have no recollection of mentioning it to him. If he recollects it in as much as the event occurred, then I think on that instance I would have to credit Mr. Dean's testimony.
Mr. Kleindienst, did you participate in a conversation with Mr. Henry Peterson and Mr. Dean concerning the possibility of going to the President because the circumstances and events indicated that there was more to the Watergate break-in than appeared?
Well, the characterization that you put at the end I don't think was relevant to our meeting, but I believe it was either Monday or certainly no later than Tuesday that Mr. Dean, Mr. Peterson, and I had a conference that took place in my office. The purpose of Mr. Peterson and myself meeting with Mr. Dean was to indicate to Mr. Dean the apprehension and the grave seriousness with which we received the news of this fantastic event that had occurred at the Watergate Hotel. To inform him, as counsel to the President, that the Department of Justice and the FBI would be compelled and would immediately launch a full-scale, intensive, thorough investigation into all the facts surrounding it, that this was a felony, that in addition to being a felony, if you can think of anything worse, it also went to the very heart of our political system, and that it was an act of such a heinous nature that we were going to call forth and bring about an investigation immediately. I think Mr. Peterson interrupted or said that either myself or Mr. Dean should contact the President personally to indicate to him the gravity of the situation, the consequences of it, and I believe Mr. Peterson said in that remark that either Mr. Dean or I should urge the President to make a statement immediately setting forth his attitude, response to this fantastic event. I believe that Mr. Dean volunteered at that point to the effect that, well, I'm going out to San Clemente, and I will convey your suggestion, Mr. Peterson, because I'll be seeing the President myself. I believe I concurred in that. I don't know how long that meeting lasted, but I think that that's the substance of what transpired at that time.
There has been testimony, Mr. Kleindienst, that shortly after this meeting there allegedly was an effort to implicate or involve the CIA as part of the Watergate cover-up, and that was done by Mr. Dean, Mr. Ehrlichman, and Mr. Haldeman. In late June or early July of 1972, were you aware of these events?
I was not aware of the meetings that have been testified here by Mr. Gray, Ambassador Helms, or General Walters. I had no knowledge of such meetings until I heard their testimony in this matter. I have a vague recollection of Mr. Gray mentioning to me sometime during that period of time that assertions were being made that there was a possible CIA involvement in the whole Watergate situation, and the fact that I believe he expressed to me that if there is actual CIA involvement in this matter, it would certainly complicate the investigation of the FBI. So that statement must have been made by him prior to the time that he had ascertained that there was no CIA involvement. Having so ascertained it, to my recollection, he never mentioned that situation to me again. To my recollection, I never had a conversation with Mr. Dean, Mr. Ehrlichman, or anybody at the White House with respect to the so-called CIA matter.
Did Mr. Gray mention to you his telephone conversation with the President on July 6, 1972?
Not to my recollection.
Mr. Kleindienst, during the summer of 1972, were you aware that Patrick Gray was making available to John Dean FBI teletypes and 302s?
No, sir. First time I became aware of that was in the confirmation hearing of Mr. Gray to be the permanent director of the FBI.
Had Mr. Dean spoken to you about the possibility of the FBI supplying to the White House such documents?
Mr. Dean raised the question with both myself and Mr. Peterson. Both of us were very quick to tell him that we would not give him raw investigative data from FBI files. I told him, based upon his representation to us and my belief throughout this matter, that he was counsel to the President, he represented continually, he was dealing directly with the President, that the President had delegated him to more or less be responsible for an overview of the investigation insofar as it might relate to White House personnel. I told Mr. Dean that since I had been in the Department of Justice, I hadn't been Attorney General but a week when this fantastic situation occurred, that it had always been my policy, and one that was shared by Attorney General Mitchell, that only under the most restricted circumstances should raw FBI investigative data be given to anybody. I believe I did indicate that we wouldn't mind summarizing pertinent information that was relevant to his inquiry orally for him so that he could make a report to the President. I believe I also indicated that if there was a particular file that the President of the United States personally wanted to see, that I would be willing to take that file personally up to the President, sit down with the President, and let him look at it, and then bring it back.
Mr. Kleindienst, during the reporter, during the summer of 1972, were you aware or made aware of a Saturday night phone call from Mr. John Ehrlichman to Henry Peterson?
In the summer of 1972?
Yes, summer or fall, excuse me.
I don't know if it was an evening call. I became aware of a call that Mr. Ehrlichman made to Mr. Peterson, I believe in the middle of the day, sometime between July 7th or 8th and August 8th or 9th, at a time when I was at the Pocono Lake Preserve in Pennsylvania with my family on a vacation. I became aware of such a call at that time.
How did you become aware of it?
I became aware of the call because Mr. Ehrlichman called me. He started the conversation out, I think, by saying either Dick or General, depending upon the nature of the conversation and how he would address me. He said, I have just talked to Henry Peterson, and I'm very upset about my conversation with him because I gave him an instruction which he refused to follow. And I think my first reaction, which was again rather abrupt and instantaneous, was, what were you doing talking to Henry Peterson in the first place? And giving him instructions of any kind. And he said, well, never mind that. I asked him to have the FBI and the United States Attorney's Office not harass Secretary Stans with respect to interrogations, just not to harass the Secretary. And I said, John, you've got to be out of your mind. What did Mr. Peterson say to you? Well, I think he said, in a polite way, he told me to go to where. And I said, well, Mr. Ehrlichman, I think by that time I might have been calling him Mr. Ehrlichman because I was very upset. I said, you're awfully lucky that Henry Peterson is the kind of man that he is, that he doesn't blow off the handle. I said, if he resigned today and had a press conference and repeated your conversation with him, you could probably be involved in an obstruction of justice complaint. And I said, Henry did exactly what I would expect him to do. Then I remember saying to Mr. Ehrlichman, I said, John, I never want you again to call up anybody in my department and give them a specific instruction. I said, if you have something to convey to Mr. Peterson or anybody over there, you can call me. He said, well, I can't reach you all the time. And I said, well, John, we've always transacted most of our business on the telephone. I had a telephone installed up here to be available to you and the President or anybody else 24 hours a day. And he said, well, I will not agree to that. And I said, all right, John, if you won't agree to that, then I'll come down Monday. I would like to meet with you and the President, and if the President tells me that you have the authority and the power to give specific instructions to people in the Department of Justice, then I will submit my resignation. At that point, Mr. Ehrlichman then treated the matter lightly. He said, oh, don't get excited. I was only kidding. Don't worry about it. It will never happen again. And I can say to you that it never did happen again.
Now, Mr. Kleindienst, am I correct that Mr. Stans did not actually appear before the grand jury?
That is my understanding.
And how did that come about in view of your conversation with Mr. Ehrlichman?
Well, that came about as a result of conferences that I had with Mr. Peterson. Mr. Peterson said that if you're dealing with persons of high position, persons of great notoriety or prestige, it is not uncommon, depending upon the circumstances, instead of having them appear before the grand jury directly, is to have them interrogated by an assistant United States attorney or the United States attorney with a court reporter and give them questions and get answers from them. Otherwise, the same ground rules would apply. They wouldn't have a lawyer with them. Their attorney could be in the next room, and if they wanted to consult with their attorney, they could step out and do that. He said that particularly he saw no objection to it in view of the fact that as of that time there was no evidence of any kind in our possession that would indicate culpability or criminal conduct on behalf of Mr. Stans. I have had very little experience with the grand jury procedure. I authorized that procedure with respect to Mr. Stans, and I will take personal responsibility for it.
Now, before I ask you your relationship with John Ehrlichman in reference to the Justice Department during this period, I'd like to read a few sentences from John Dean's testimony before this committee from page 2308. Quote, throughout the Watergate investigation, Haldeman and particularly Ehrlichman had complained about Mr. Kleindienst's passive role in the investigation and prosecution. Haldeman and Ehrlichman were both aware of the strained relationship between Kleindienst and the White House. I knew that Ehrlichman was riding hard on the Justice Department in an effort to undermine Mr. Kleindienst. I also knew from conversations with Kleindienst that he had little affection for Mr. Ehrlichman. Is this a fair statement of your relationship with Mr. Ehrlichman?
Oh, I think the last statement that Mr. Dean made at that time would have been subjective in nature. I don't think I had a feeling one way or another in that way about Mr. Ehrlichman. I had had, generally speaking, a satisfactory working relationship with Mr. Ehrlichman. He had a very difficult assignment and role to fulfill on behalf of the President of the United States. I often wondered how John Ehrlichman could really take on to himself the multitudinous chores and responsibilities that he did. I made it a point, to the extent possible, to work with and get along with everybody at the White House, and indeed in the government, as a means by which I would discharge my responsibility in the government. I didn't know, nobody told me that I wasn't getting along with the White House. I have a personality and personality characteristics which people tell me sometimes can be irritating. And I am sorry about that, and I suppose I could have irritated people up there from time to time. So far as a passive role at the Department of Justice, the decision that I made on June 17th, when I became aware of this, in terms of my role as the Attorney General, was essentially this: that I should not do anything more or less in this as a major investigation than I would in any other case. In every other case that I ever was involved in at the Department of Justice of a criminal nature, I looked to Mr. Henry Peterson to be primarily responsible for the direction of the investigation. And let me say this about Mr. Peterson. I believe that Henry Peterson is the finest career lawyer that this country has ever had. In 4.5 years of association with him, I found him to be intelligent, fair, courageous, honest, dedicated to the administration of our criminal justice laws. And I suppose that of all the people that I was associated there with who would be under me in the department, I respected him more, looked to him more for advice and counsel, relied upon him more, and thanked the Lord constantly that there was a man like Henry Peterson. My admiration for him is such that I believe that Henry Peterson is the first career lawyer in the Department of Justice who was ever appointed by the President to be an Assistant Attorney General. And I thought it was a great compliment to his career of service. Consequently, on any other, as I did in any other criminal matter, I looked to Henry Peterson. I probably saw him several times a day. I did not absolve myself of the ultimate responsibility as the Attorney General in the matter, but I relied upon Henry, and I got my information from Henry Peterson. With the exception of one event, I never talked to Mr. Silbert or Mr. Glanzer or Mr. Campbell or the United States Attorney. I never gave them any directions. If there was a policy matter that Mr. Peterson would submit to me, which was proper for me to discharge as the Attorney General, I made those decisions. If they were right, I'll take the credit for them, and if they were wrong, I'll take the responsibility for them. That could have been, to people at the White House, a passive role in the Watergate case. It's the role that I elected to take, and it's the role that I tried to pursue while I was there until Sunday, April 15, 1973.
Mr. Kleindienst, I'd like to turn to a meeting that apparently took place among you, Mr. Dean, and Mr. Ehrlichman on July 31, 1972. Do you recall that meeting?
Mr. Dean, Mr. Ehrlichman, and myself?
Yes.
Without something else to prod my memory, I have no recollection of that.
Well, I'll read from page 5285, Mr. Ehrlichman's testimony before this committee. There came a time when there was a feeling that, at least on my part, based upon what Mr. Dean was telling me about the unfolding of this thing, that Mr. Magruder may have had some involvement. And that culminated in a meeting with the Attorney General at the end of July, on the 31st of July, where Magruder was specifically discussed. But just where in there I acquired information, I can't tell you.
I have no recollection of any such meeting. The only recollection I have of anybody ever saying anything to me about Mr. Magruder was Mr. Peterson's characterization to me after he appeared before the grand jury as a witness, that he said Magruder just barely, got by. As a result of our conversation, I gathered he meant by that he didn't sound like a credible witness. However, there was no other evidence available to the U.S. Attorney to contradict what he said, and that's the only characterization of Mr. Magruder that I heard. Incidentally, Mr. Dorson, let me make another gratuitous statement, if I may. And that's about these three young lawyers in the United States Attorney's Office who conducted this investigation. To me, those three, along with Mr. Peterson, are the unsung heroes of the Watergate case. I think a lot of people should be given a lot of credit, the Senate, the press, Judge Sirica. But there haven't been very many people around talking about these career people in my department. These three young men were career lawyers. I believe that they're all Democrats. They were there before we came in. They were given this assignment by the United States Attorney, and they were never interfered with under very difficult circumstances. The obvious political notoriety of it, the problems with respect to the press, the interest of the nation with respect to this terrible, reprehensible event that had occurred, impose upon these young men a burden that very few prosecutors, I think, have ever had. I had complete faith in them throughout this thing. I do today, and I hope someday that they will get the recognition that they really deserve for conducting a thorough, comprehensive investigation. And let me conclude my gratuity by this remark, that this case, it seems to me, was ultimately broken not by Magruder and Mr. Dean going to the Senate or the press or the judge, but by going to the United States Attorney's Office in the District of Columbia, to Mr. Silbert, Mr. Glanzer, and Mr. Campbell, and giving them the information that really has unfolded this and brought us to the point where we are today. Excuse the interruption, but I wanted to make that testimony for some very fine men that I admire very much.
Fine, Mr. Kleindienst. I'd like to move ahead to February 22nd, 1973, and to your meeting with the President on that date, and ask you if you can summarize for the committee what occurred.
February 22nd, 1973. Without something else to prod my memory, Mr. Dorson, I haven't the slightest idea. Incidentally, for the benefit of the committee and counsel, throughout the time that I was in the Department of Justice, I did not keep lengthy memos of my conversations. I didn't write memos to file. I didn't write self-congratulatory memos back and forth. When I dealt with people at the White House and with the President of the United States, I did it as a cabinet officer, as the Attorney General, in good faith. I gave them my best opinions at the time, and I did not keep copious memoranda for the benefit of my grandchildren 50 years from now or anybody else. Consequently, and I think you can see there as a result of my logs that it would not be uncommon for me to have 50, 60, or 70 telephone calls or meetings in a day. So unless you have something else about February 22nd with the President of the United States, I haven't the slightest idea what I did there.
Well, I believe we raised it with you in one of the preparatory sessions, and Mr. Dean testified about it as the meeting in which you were trying to be brought back into the family, where the agenda was prepared, and I think efforts were made to have you stay on as Attorney General past the deadline which you had set for yourself.
Well, I didn't know that I wasn't a member of the family. The President of the United States, incidentally, never gave that indication to me. I never had anything but the finest relationship with him. Again, for the record, the only instruction the President of the United States ever gave me at any time after Watergate was to see to it that the Department of Justice and the FBI conducted a thorough, complete, intensive investigation, and I think the phrase that he used several times was, "Let the chips fall where they will." If that was the meeting, however, at which the President discussed with me my tenure in the Department of Justice, and I don't know if it was that date or not, I did have such a meeting, because I recall the President asking me to come up to see him on rather short notice. By way of preface, before the election, I communicated to the President through Mr. Mitchell the fact that I would like to stay as the Attorney General until September of 1973, which would be coterminous with the expiration of my term as President of the Federal Bar Association. My reason for doing so was one strictly of financial reasons. I'll have 3 children in college this year. My service in the government had depleted a rather modest estate, and I just could not afford to longer stay in the government of the United States. After the election, when I had meetings at Camp David, I went to Europe for 10 days and had meetings with respect to drug enforcement matters in London, Paris, Madrid, and Bonn. I was informed by Mr. Haldeman and Mr. Ehrlichman that my request had been acquiesced in, and then I had a subsequent meeting with the President in which he likewise said that that would be fine. At a meeting after the inauguration and before April 15, whether it's February 22nd or not, Mr. Dorson, the President called me in and he said, "Dick, I don't want you to think about leaving as the Attorney General in September." He said, "I understand your personal circumstances. It's going to be a hardship for you, but I have to have you stay until this Watergate situation is over." He said, "I just can't have a new Attorney General, a confirmation and all the problems, and somebody coming in brand new right now." As I always have tried to do, I try to respect the wishes of the President of the United States. I said, "I hope it's not going to be long after September. I won't be thinking of that date now. I want to get out of here as soon as I can, but I'll agree with you that I will not submit my resignation in September."
Mr. Kleindienst, I'm going to pass by certain other events that occurred in this period, including any role you may have played in the confirmation hearings of Mr. Gray, your receipt of any records from the CIA, and discussions as to the role you were perhaps to play in connection with this committee, and direct your attention instead at this time to a conversation I believe you had with Mr. Ehrlichman on March 28, 1973. Do you recall that conversation?
No, sir.
We have shown to the witness what purports to be a transcript of a conversation on March 28, 1973 between Mr. Kleindienst and Mr. Ehrlichman.
Is that the one that Mr. Ehrlichman taped?
That is correct,
Yes,
Mr.
then
Kleindienst.
I've had my memory vividly refreshed with respect to that conversation.
And Mr. Kleindienst, did Mr. Ehrlichman, before that conversation start, tell you he was taping it?
No, sir. If he had, some of the words that I used and that appear on this exhibit would not have been said by me, Mr. Dorson.
Well, in the interest of moving along, I did not intend to question you about the content of that conversation, but merely about Mr. Ehrlichman's not advising you. Do you know whether Mr. Ehrlichman made a practice of recording these calls?
I learned of this as a result of these hearings. I don't think I have appropriate language in a public hearing of this kind to describe the reaction that I had when I learned of this. I think it's reprehensible. I think it's incredible. The concept of somebody at the White House taping a telephone conversation with the Attorney General of the United States when he's talking to them about business that relates to the President of the United States is just beyond my comprehension. Like I say, I don't want to be subjective, but I don't think I have at my command language that adequately expresses my feelings about this incident.
Mr. Kleindienst, does that document that I've shown you appear to be an accurate transcription of the conversation?
I think so.
Mr. Chairman, in the absence, may I request that transcript be placed in evidence?
I would like to have the opportunity, for the benefit of two persons who used to be friends of mine, Senator Weicker and Judge Sirica, to explain some of concepts that I had and why I used some of the language that I did as a result of my conversation with Mr. Ehrlichman.
Well, Mr. Kleindienst, just because I do not want to monopolize your time here, I just assume that that will be done at another occasion here. I can assure you, if nobody else does it, I will come back to it.
Thank you.
Let the record show the Ehrlichman tape of the conversation with the witness is the transcription of the Ehrlichman tape of his conversation with the witness will be marked appropriate as an exhibit and received in evidence as such.
Let the record also show that there's no reason for Mr. Kleindienst to use the expression "used to be a friend of mine."
Thank you, Senator.
Mr. Kleindienst, in early April 1973, did you have a conversation with Mr. Ehrlichman on the subject of Judge Matthew Byrne becoming the director of the Federal Bureau of Investigation?
On or about April 5th, as I recall, I was in Los Angeles, California, attending a regional United States Attorneys Conference. Either while I was there or before I left on the night before the meeting that I'm going to describe, I believe I got a telephone call from Mr. Ehrlichman or somebody on his staff indicating to me that perhaps the president was going to want to talk to me at San Clemente. I believe I indicated that my reservation to leave was Saturday morning because I either wanted to get home or had a meeting Saturday night in Washington, D.C. I was then informed that to stand by for a helicopter to come near the hotel where I was staying to early the next morning to take me to San Clemente for the purpose of meeting with them and the president. I believe later that night I was informed that the decision was made for me to go there, and at 8 o'clock in the morning I went to a lot near the hotel. A helicopter came, and I'm in San Clemente. That's the first and only time I was ever at San Clemente. My meeting started with Mr. Haldeman and Mr. Ehrlichman. Most of the meeting was consumed with a discussion based upon my recommendation of the selection of a special prosecutor for the so-called Watergate situation. This is a suggestion that I first started making to the White House in September of 1972, and a suggestion that I've made many times. The suggestion was rejected both by Henry Peterson and the White House for essentially the same reason. Mr. Peterson said that if you bring in a special prosecutor, that would be a slap at the career people in the Department of Justice and an insinuation that they haven't done their job. They're not entitled to that. And the White House kept saying to me that it would be a reflection upon me as the Attorney General if I had to bring in a special prosecutor. Somebody would say that I hadn't done my job. My answer to them at all times was, well, we've done a great job. If we can get a fair, objective, credible, outstanding lawyer with knowledge and experience to come in here and take a look at what we've done, I had such confidence in what we've done that he would say we'd done a good job, and I thought that would be good in view of the politics of the situation. And then secondly, I wanted somebody to make the ultimate prosecuting decision who was not a presidential appointee, so that persons who had legitimate interest in this, politically or otherwise, could not say that any decision, ultimate decision, was a political decision. And I thought that from the standpoint of the appearance of justice, the confidence of the people of the United States in our criminal justice system, that it would be a very worthwhile thing. I never publicly revealed these recommendations of mine. I always felt that the response by the career people in the department and the White House was legitimate and in good faith, and I never had the practice of calling a press conference every time somebody at the White House disagreed or the president disagreed with one of my recommendations. But in any event, by April 5th, apparently they were ready to discuss this matter very seriously. And we spent some time discussing how it would come about, who it might be, what his role would be, what delegation of responsibility I would give him, how could we select a person. And I had a lot of ideas because I'd been talking to quite a few people about it, and I even had some names. I think I had 3 in particular, and I remember Mr. Ehrlichman saying, well, come up with a list of 5 possible names. And I said, I'll try, but I don't know if you need 5. But in any event, that consumed most of the conversation. I recall the question of the new director, permanent director of the FBI came up, and they asked me for my recommendations. I had 2 names that I recommended to them and that we discussed that day. One was Henry Peterson, and one was Judge Byrne in Los Angeles. I think that the consensus of our conversation with respect to Mr. Peterson was that you couldn't find a better, more qualified person to be permanent director of the FBI, but because he had been in charge of the Watergate investigation at the Department of Justice as the Assistant Attorney General, he could be controversial and that he might have difficulty being confirmed. In other words, if you had him, you might have a Watergate hearing as part of his confirmation. I understood that and the reality of it, having gone through a confirmation hearing of my own a year before. And then they asked me why I was so strong on Judge Byrne. I think that they were surprised to learn of my very close personal friendship with Judge Byrne. I met Judge Byrne when I became the Deputy Attorney General. He had been appointed United States Attorney for the Central District of California, that is to say Los Angeles, which is one of our largest U.S. Attorney's office under President Johnson. When we came in 1969, there were many serious cases and matters that were still pending in his office. He came highly recommended by everybody at that time, the bench, the bar, Republicans, Democrats, and Mr. Mitchell and I prevailed upon him, if he would, to stay on for another year as the United States Attorney in this administration so he could administer the caseload that he had in that very large and significant office. He consented to do so, and I think that that was kind of an act of patriotism on his part to stay on. I think he's quite identified with the Democratic Party in California and discharge fairly and responsibly the duties of that very significant office under a Republican president. As a result of that, Matt and I became very good friends. As a result of that friendship, my estimation and opinion of him grew daily. From the standpoint of his intelligence, his ability, his knowledge, his conviction, his experience as a prosecutor, his whole concept of society, and his fairness. I was very pleased when Senator Tunney and Senator Cranston recommended him to be a federal district judge. The way we had allocated it, it was their turn to come up with one, and I wanted to suppress my pleasure to those 2 senators for fear of my prejudice mad. He is an outstanding judge. And then I think, and I gave him those qualities. He's a bachelor. He's about 40 years of age. He's dedicated to the law. And I said, in these troubled times, as a result of Watergate, as a result of Pat Gray's misfortunes, that this would be regarded, I think, with complete credibility. There could be no charge of politics because of his bona fides as a Democrat. And then I said, you'll have a man who will be fair and forthright and honest in this job. I don't know whether Mr. Ehrlichman suggested to me that I contact Mr. Byrne or not. I do know that in that conversation I said, or I believe that I did, my recollection is, that I have not talked to Matt Byrne since the Ellsberg trial started. I said I've expressed good wishes to him through mutual friends in Los Angeles, but that he and I have just not talked together since the Ellsberg trial started. Neither one of us wanted, or at least I, and I'm sure he felt that way, wanted anybody to think that in the appearance of justice that I was going in his back chambers and trying to get some special consideration for the government in that very significant and vital case. I have no recollection of Mr. Ehrlichman ever indicating to me at that meeting that he himself was going to talk to Judge Byrne. Because of the standard that I had set for myself in not talking to Judge Byrne throughout this trial, if Mr. Ehrlichman had indicated to me that he was going to, I am confident that I would have said, John, you cannot do that while this trial is going on, or at least you should not. But really, you, on behalf of the President, are really no different than I as, you know, a member of the President's family. In any event, when I first learned of the fact that Mr. Ehrlichman had contacted Judge Byrne, I know I registered a feeling of surprise that such a meeting had occurred. Now, I know Judge Byrne well enough to know that he did nothing improper as a result of that meeting, of those meetings, nor would he permit anybody else to put him in a situation of impropriety. The Ellsberg trial was just about ready to come to a conclusion. The evidence was just about in and was going to go to the jury. And because of the delay that had already occurred, I didn't think there was that kind of a problem. Mr. Gray was continuing to act as the acting director of the FBI, and I thought with great distinction. That is what I recollect of the Byrne incident.
Mr. Kleindienst, I just want to allude to a few of the subsequent events briefly at this time, however important they are. I do not want to pursue it in detail now. But am I correct that on the early morning hours of April 15th, 1973, you had a meeting with Mr. Peterson, United States Attorney Harold Titus, and the prosecutors at your home?
It was just one of the prosecutors, and that was the chief prosecutor, Mr.
Silver.
Silver.
And am I correct that this meeting dealt with the disclosures of Mr. Magruder and Mr. Dean to the prosecutors?
Yes, sir.
Following that meeting, am I correct that you made an appointment to see the President later in the day on April 15th, 1973?
That meeting commenced at approximately 1 o'clock in the morning. It terminated around 5 o'clock in the morning. I was up at 8:30. As a result of that meeting, we agreed that I had to see the President. I put a call in the White House at 8:30. The President returned my call at 9:30. I told him it was absolutely imperative that I see him right away. He said that I have the Sunday service at the White House at 11. I told him that rather than go to church with my wife and children, I'd go up there and attend that service at 11 and be available to see him after that was over. I think the reception lasted until approximately 1 o'clock, and around 1 o'clock in the afternoon, approximately, I met with the President in his office in the Executive Office building.
Now, am I correct that at least part of the meeting was devoted to briefing the President, and that one of the decisions made on the afternoon of April 15th by you would be that you would, in effect, withdraw from the supervision of the prosecution of the Watergate case?
The whole meeting was devoted solely to talking about the information that I had obtained that night and the consequences that inevitably must flow from it.
Now, Mr. Kleindienst, I'd like to show to you a document which you provided the committee dated April 15th, 1973. First page is typewritten. The page under it is handwritten, and I ask you if you can identify that for the committee.
Yes, I know what you have in your hand, Mr. Dorson. I furnished it to the committee. The document underneath in my handwriting is a document that I wrote out in my office in the presence of Mr. Peterson after he and I had met with the President of the United States, in which I set forth the reasons why I had to recuse myself from any further contact or involvement in the Watergate case, and in which I designated him to substitute for me as the Attorney General of the United States in anything further concerning the Watergate case. I further requested that he communicate this decision of mine and the contents of this memorandum to the United States Attorney Titus, to Silbert, and to Acting Director Gray of the FBI. I signed it, and I had Mr. Peterson sign it, indicating the time that he received it. It was important for me to establish the time when I no longer had any connection with the Watergate thing. I then Xeroxed a copy of my handwritten statement and gave it to him, and I kept the original. The top document that you've handed me is the typed document of my handwritten document.
Mr. Chairman, I request that the document identified and summarized by Mr. Kleindienst be admitted into evidence.
It will be received and appropriately marked as an exhibit and admitted in evidence as such.
Mr. Kleindienst, what does the word recuse mean in this context?
It's a technical word used by lawyers, and particularly those in government service, which signifies that for one reason or another, usually ethical reasons, that you withdraw from any further participation in a particular matter.
Mr. Kleindienst, when did you first learn of the fact, which apparently is a fact, that White House employees or persons working at the behest of White House employees burglarized the office of the psychiatrist of Dr. Daniel Ellsberg?
I learned that amazing bit of information sometime in the morning of Wednesday, April 25th, 1973.
And how did you learn it?
Mr. Peterson called me and said that he had a very urgent matter, and could he come up to my office. I don't know if I had anybody in there, but if I did, I got him out. He came up in a minute and handed to me, without saying anything, a copy of a memorandum dated April 16th from Mr. Silbert to himself, a buck slip from him to Mr. Kevin Maroney, the Deputy Assistant Attorney General for the Internal Security Section of the Criminal Division, and a memo from a Mr. John Martin to Mr. Maroney, dated sometime that week. I do not recall the date of that. It would have been after the 16th of April and before April 25th. I read the two memos after I had recovered my composure and had uttered some of my abrupt remarks. He and I then began to discuss the dire, serious nature of this amazing revelation. We discussed it for some time. It had a fantastic potential effect upon the trial of the Ellsberg case. It had certainly a fantastic potential with respect to the constitutional rights of Mr. Ellsberg, a defendant. And I believe our conversation kicked around until just before noon. At noon, I had an appointment to go with Solicitor General Griswold to the Department of Defense and be with him at a luncheon in his honor by the Judge Advocate General's Corps of the United States Army. I remember in the car outlining a hypothetical situation to Dean Griswold as a means by which, as I did quite often, to get the benefit of his advice and his wisdom and his counsel. Prior to the time that I went to lunch, Henry and I had arrived without difficulty and simultaneously at two conclusions. Number one, that we had to transmit this information immediately to Judge Byrne through our chief prosecutor, Mr. Nissen, in Los Angeles without delay. And number two, that because of the explosive, just because of the nature of the situation, that I should immediately contact the president and inform him of this situation and also of what I was going to do. Before lunch, I then placed a call to the White House. Usually when you call and want to see the president, they want to know what you want to talk to him about. I was very insistent in this instance to say that it was a matter of great urgency, but I couldn't describe the reason for the meeting. When I got back from my lunch in honor of Dean Griswold, soon thereafter I received a call from the White House that if I could come over right away, I could see the president. I did. I gave him, I had those memos, those papers with me. I had a couple of cases that, you know, I could discuss in a little notepad, but I didn't give him those citations. He, without hesitation, one moment's hesitation, said that the course of action that I was going to pursue was the only thing possible to be done. He caused the memos to be Xeroxed. He kept a copy of the memos, and I left. The meeting didn't last very long because there was no problem in his mind or my mind or anybody else's mind as to what we had to do under the law.
Did you have an impression one way or the other as to whether this was the first time that the president learned of these events?
I don't know if I gathered that impression, Mr. Dorson. I know he was very upset about it. He was very upset about it.
Did he say whether this was the first time he'd heard?
To my recollection, he did not. And I just wouldn't know. The fact that he was so provoked, the language that he used to describe the idiocy of the event, indicated to me that he had not learned of it, you know, except just soon, you know. But I don't believe I asked him. It wasn't my habit to interrogate the President of the United States, and all I know is he was very, very provoked.
And was an announcement made later that day?
Well, either while I was at the President's office or when I came back, the memos were teletyped to Mr. Nissen, the chief prosecutor in Los Angeles, and Mr. Peterson then thereafter gave him instructions as to what he was supposed to do. I believe those instructions were that he was to give them to Judge Byrne and then be guided by Judge Byrne's decision.
And am I correct, Mr. Kleindienst, that approximately 1 week later you left the Department of Justice?
Yeah, let me explain the reason for the delay between April 16th and April 25th. I think one of the important things that had to be determined by the Department of Justice before a disclosure of this information would be made to Judge Byrne was whether or not the fact of the burglarization of Dr. Ellsberg, psychiatrist, was known to anybody in the Department of Justice at any time before or during Dr. Ellsberg's trial, because that would be one of the most significant inquiries that the judge and the other side would have. Indeed, if it could be made known that any of our attorneys or the prosecutors were aware of this fact and did not disclose it, they would have been guilty of contempt of an order of the judge, and they would also have been guilty of dereliction in their duty as a prosecutor of the United States of America. The Martin Memorandum that was addressed to Mr. Maroney clearly and unequivocally set out the fact that nobody in the Department of Justice had any advance knowledge of this before or during that trial. And it was, I think Mr. Peterson was delaying bringing this matter to my attention until that fact could be ascertained, so that in no way was Mr. Ellsberg prejudiced, you know, in the trial of this case as a result of either our knowledge of any of the contents, and I've subsequently learned that they didn't get any information out of the psychiatrist's office anyway.
Mr. Chairman, I have no further questions.
Minority Counsel Fred Thompson begins his questioning of former Attorney General Kleindienst in just a moment. Public television coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Fred Thompson, minority counsel for the committee, now asks Kleindienst about John Dean.
Mr. Thompson.
Mr. Kleindienst, as I understand it, Mr. Dean came to you shortly after the break-in and indicated that he was looking into the matter for the White House or keeping abreast of the matter for the White House. How did he...
I think he was a little bit more specific than that, Mr. Thompson. The representation that he made to me and to Mr. Peterson throughout was that he was doing this for the President of the United States and that he was reporting directly to the President. He had been delegated by the President to be posted and informed throughout the course of the investigation to enable him to report directly to the President of the United States.
Did you have any subsequent contacts with him that would indicate whether or not he was, in fact, carrying on what he described his job to be?
I had no reason to doubt that assertion by him until I met with the President of the United States Sunday afternoon, April 15th.
Did he tell you on more than one occasion that he was reporting directly to the President?
I would say just continually.
Was this a matter that concerned you somewhat, exactly what his role was?
I assumed that that's what he would be doing as counsel to the President.
Did you consider this a proper role for a man in his particular position as counsel to the President?
As counsel to the President?
Yes, sir.
I thought it was what he might be there for.
All right,
I had nothing but the highest opinion and estimation of Mr. Dean as a result of a year and a half that he served as a deputy to me when I was a Deputy Attorney General and throughout this whole situation. Had no reason to question that at all.
You stated that he approached you concerning the FBI files, and you in effect told him that if the President needed to see a particular file, you'd deliver that file yourself, and that you did not know that Mr. Gray was giving him files. I assume then, if we can reconstruct this matter, that he approached Mr. Gray after he approached you.
I don't know.
Did Mr. Gray ever tell you that he was giving files to Mr. Dean? Would you consider, with your relationship with the director of the FBI, if he was in fact giving files to Mr. Dean, would you consider this a matter that he would properly report to you or discuss with you before you would do so?
I don't know. I think if Pat, who I have a lot of sadness about some of the people involved in this, and I think Pat occupies one part of my heart. I think if Pat Gray had been aware of the fact that John Dean had made this request to me and I had said no, or if he had raised the question to me and I had said no, I am certain that Pat Gray would have, complied with my direction. The only way I can explain it is that I think Pat justified it in his own mind, and I think there is a basis for justifying it in his own mind. He had no particular reason to know how I felt about it. So I guess it's just a subject matter that when you're busy as the director of the FBI and the Attorney General of the United States is, it just didn't come up. I know if he had told me that, I would have specifically directed him not to do so.
Mr. Kleindienst, when Mr. Ehrlichman called you on April 14, did he discuss the fact that he was conducting or had conducted his own investigation?
Yes, he did, and based upon revelations made here, I assume that that's one of the calls that was taped. On Saturday afternoon, April 14th, I was again out at the Burning Tree Club. I want to tell the chairman that I only play golf on Saturday and I don't do it on Sunday, and a lot of these meetings occurred on Saturday, so I don't want you to think I'm completely profligate.
Well, the chairman would observe that the chairman, has never had a golf stick in his hand.
Well,
I've had found too many other things to do.
Well, I feel sorry for you, Mr. Chairman. Well, anyway, back at Burning Tree. About 3:30 in the afternoon, I got a call from Jan Oruska, Miss Oruska, who is Mr. Ehrlichman's secretary. And she said, Mr. Kleindienst, Mr. Ehrlichman is going to want you to come down to the White House and see him this afternoon. And I said, Jan, that's all right with me if I can come down right now, because I'm going to the White House Correspondents' Dinner, and I have to be at a reception at 6 o'clock. And if it's going to be delayed, I will not be able to come down. She said, I'll call you right back. A couple of minutes later, she called me right back and said, where can you be on the telephone at 5:30? And I said, I'll be at home. She said, fine, Mr. Ehrlichman will call you at home at 5:30. I rushed home from Burning Tree, changed my clothes, and was dressed ready to go to be there by 6 so that after I talked to Mr. Ehrlichman, I could make my 6 o'clock reception. Mr. Ehrlichman started out, and again, I think he said general, but I'm not sure. I'd like to see the tape of it. General, I've been meaning to call you and give you a report, but I've been too busy and I haven't been able to do it, but I've got a report to make to you. And I said, well, what's that, John? And he said, well, I have been conducting an investigation for the President with respect to the possible involvement of White House and campaign personnel in the Watergate situation for the past couple of weeks. And I said, John, you mean you've been interrogating people with respect to their conduct? He said, yes, I have. And I think I remember saying, well, John, have you talked to anybody who indicated to you that they might have been involved in criminal conduct? And he said, yes, that's true. And I said, John, you want to be very careful. I said, that kind of information should go to the FBI. And if you don't turn it over to the Department of Justice, you might find yourself in a situation where you might be an accessory after the fact or obstruction of justice. My purpose was to try to help Mr. Ehrlichman out and give an indication of what the law was and what can happen if you do certain things. He said, well, it doesn't really make any difference anymore. And I said, well, why not, John? He said, well, Mr. Magruder has been over here at the White House this afternoon and telling us that he has been meeting with the United States Attorney's Office and giving them testimony and evidence that would implicate people high and low in the White House and in the campaign committee. I think I might have uttered some fantastic indication of surprise, and then he abruptly terminated the call, as I remember, by saying, have a good time at the White House Correspondents' Dinner, and the phone went down. Needless to say, I didn't particularly enjoy the dinner. Sometime that evening, I got a hold of Mr. Peterson and told him that I had to see him. And this is one aspect of it that I'm not precise about. My wife keeps telling me that I called Henry Peterson first, and I always believe that he called me. But in any event, I left the White House Correspondents' Dinner early. I usually stay. Gives me an opportunity to gig back members of the press after they've been gigging me all year. And I have so many friends among them. But in any event, I decided to leave early. And when I got home, I had a conversation with Henry. And he said, it's important that we get together with you tonight. That was around 12 o'clock. I live out in McLean. He and Titus and Silbert were there by 1 o'clock in the morning.
Did you ever have any other conversation with Ehrlichman as to the findings of his investigation?
No.
Did you ever find out what he, in fact, reported to the President?
No. Never had. He told me, he opened the conversation up by saying, I've been meaning to call you before now, which would indicate that he had an intent to do so, but hadn't.
Your conversation with Titus and Silbert and Peterson, did they, was it about 4 hours, I believe, from 1 in the morning until about 5 o'clock?
Yeah.
Did they tell you the substance of what Magruder and Dean had been telling the U.S. Attorney?
Yes, sir, and I got some of my wife's personal stationery and made rather copious notes of what they told me so I could report it to the President the next day.
All right, can you recount to us briefly what they told you at that time?
Well, they in effect summarized the testimony or statements or purported statements of Magruder and Dean, which in one way or another would implicate Mr. Mitchell, Mr. LaRue, themselves, Mr. Haldeman, Mr. Ehrlichman, Mr. Mardian, you name it. It was a very lengthy meeting. This is the first time since June 17th of 1972 that anybody had given me any credible evidence that any of these people were involved in any way in either the cover-up or that incident.
Did they tell you?
Two of those men are two of the closest friends I've ever had in my life, and I think one of the things that I did that night is I wept. But it was a long meeting, Mr. Thompson. And it was a comprehensive meeting, and I made comprehensive notes of what occurred.
Do you recall if they told you that Mr. Dean at that time had made allegations against the president concerning
No.
presidential cover-up?
No.
Did not?
They said that Mr. Magruder was not looking for immunity and that Mr. Dean was bargaining with his attorney for immunity, and that his statements to them were on a conditional basis through his attorney, predicated upon whether he got immunity or not.
So you went to see the president the 15th?
Yes, sir.
Same day. And did you substantially tell him what they had told you?
To the best of my ability, because I took the notes that I had written on my wife's blue stationery and I had them in my pocket, and I read from my notes.
And what was the president's reaction?
He was dumbfounded. He was very upset. He was very upset.
I believe you mentioned in an interview that he was partially consoling you.
Well, I was very upset about this, Mr. Thompson. I don't think since my mother died when I was just a young boy that I've ever had an event that has consumed me emotionally with such sorrow and sadness as this situation. And he was very considerate of my feelings.
Mr. Kleindienst, did you have occasion any time after the break-in in 1972 of talking to the president either in person or by telephone about the Watergate matter?
I didn't. I know I had a conversation with him almost immediately afterwards.
Do you recall what was said in that conversation?
Well, what was said about that is, he said, Dick, I told him what we were doing, and he said, Dick, you've got to have a thorough, intensive, complete investigation of this. And I think that's when he first used the term, let the chips fall where they will. During the summer, we had the Republican convention. I was gone for approximately a month up in the Poconos, and then the campaign came along. I didn't have many conversations with the president during that period of time, none that I can specifically recall. I had 2 meetings with him up at Camp David after the election and after I had returned from Europe. We didn't have to talk much about the Watergate. I knew what I was doing, he knew what I was doing, but the extent to which it was brought up was in the same context.
Mr. Kleindienst, I have no further questions. Thank you, sir. Thank you, Mr. Chairman.
Did John Ehrlichman tell you he was bugging, use that word unadvisedly, rather than recording, your conversation with him?
No, sir. If I ever felt that he had, I don't know if I'd ever talk to him again.
Now, you stated, as I understood your testimony, that the president indicated by his conversation when you reported what you knew about the Watergate affair to him that...
What meeting are you talking about, Mr. Chairman?
The 15th,
yes, sir.
I believe, of April, that he indicated by his reply that he didn't know, that he was ignorant about the Watergate affair.
Well, I would say that the information of the nature that I described with him would have come to his attention contemporaneously. If Mr. Ehrlichman is talking to Magruder all afternoon, the day before, I would just assume, although he didn't say, that Mr. Ehrlichman would have made a report like this to the president. But I would gather from my meeting with the president that he had no such knowledge until immediately prior to my meeting, Mr. Chairman.
Yes. Now, do you agree with me that of all the human beings on the face of the earth, that the one who knows most about this is the president himself? That is about the present state of knowledge.
You mean that the one person who knows most about this situation?
Yes. No, the one that knows more about what the present state of knowledge was between June the 17th, 1972 and April the 15th, 1973 is the President himself.
Well, Mr. Chairman, I would agree that the President knows more about what he knows than what I know.
That's what I would think, yes.
Yeah. I know more about what I know than he knows what I know.
Yeah. And in July, sometime between July the 7th and August that 9th, I believe you said, John Ehrlichman called Henry Peterson and entered a protest that he was harassing former Secretary Stans because he was the prosecuting attorneys were harassing Secretary Stans because they were calling upon him to perform an obligation which devolves upon all citizens of the United States.
That's essentially it. I think Mr. Peterson will be a better witness as to the conversation between Mr. Ehrlichman. My attention really wasn't so much consumed with what Ehrlichman said to Peterson and Peterson said to Ehrlichman. I was interested in Mr. Ehrlichman not giving directions to people in my department.
He was a person that had been delegated to the President with a tremendous governmental power. John Ehrlichman undertaken to dictate to the Department of Justice how witnesses should be treated.
Yeah, I think Mr. Ehrlichman made a mistake on that. He never did it again, and he probably wishes that he hadn't done it.
Well, now, as I understand from your testimony, if I'm wrong, you can let me know. You agreed that Assistant Attorney General Peterson could excuse Stans from going before the grand jury and let him testify by deposition in some private offices or public offices apart from the grand jury?
Mr. Peterson made that recommendation to me, and I will take the full responsibility for that, Senator Irvin.
Well, that troubles me a little bit because of my conviction that all men, regardless of whether they're princes or peasants, or former cabinet members and just ordinary Americans ought to stand equal and be treated equally before the law. It also gives me misgivings for another reason. Under the statute, we have grand juries composed of anywhere from 16 to 23 men, and it's a part of the judicial process that they should have an opportunity to cross-examine a witness.
May I make a point right there, if I please, Mr. Chairman? I think one of the things Mr. Peterson said to me when we discussed this thing was that if the grand jury, when they received his written testimony, had any reason for wanting to interrogate Mr. Stans directly, that then Mr. Stans would be required to go before the grand jury.
Well, don't you agree with me that a grand juror could cross-examine Mr. Stans better than he could a piece of paper?
Sure.
Words on it.
I think, and I'm not trying to rationalize or debate the matter with you, Mr. Chairman. You take the situation, the context in which I found it, there was no reason to suspect Mr. Stans of illegal conduct. I know that in this administration with, let's say, very important Democratic officials, they had a procedure like this, so... But I think now, with the hindsight that we are able to exercise, maybe I would have done something different.
Well, I think that when John McCormick was excused from going before the grand jury, that was also an affront to justice. Now,
I'm not prepared to dispute that, Senator. That's why I personally will take the responsibility personally for
I'm not saying anything, I'm not insinuating there's anything more than error of judgment. I'd like to make that plain.
I understand that, but I want to make it clear here that I'm not trying to impose the responsibility for that decision on anybody else but myself.
And I might confess that I have an overriding sense of curiosity as to what Secretary Stans stated in his deposition. I've asked for copies of the deposition, but it appears not to be forthcoming.
Well, there's another law, I think, Senator Urban, that precludes or prohibits the disclosure of testimony before a grand jury to anybody.
Yes, I'm not asking for testimony before the grand jury. I'm asking for the testimony taken before the prosecutors. That's quite a different situation.
No, that was that was testimony taken for the purpose of the grand jury, and it was given to the grand jury.
But I know of no law which exempts testimony taken before prosecutors. It's only testimony taken before grand juries. I don't want what was taken before the grand jury. I want what was taken before the prosecutors. Now, this troubles me not only from the fact that Stans was given, notwithstanding the fact that I think presidents and secretaries have feet of clay just like the rest of us and are entitled to no special consideration. But it also troubles me. Well,
The demonstrators who interrupted Chairman Ervin at this point attempted to read a statement protesting alleged CIA involvement in domestic intelligence operations. Capitol Police escorted the 9 men and women from the hearing room, but on orders from the chairman did not arrest them. Some of the young people claimed to be members of a group called the National Caucus of Labor Committees of New York City. Outside the building, about 50 other demonstrators circled and chanted slogans criticizing the Central Intelligence Agency.
The lady will please desist from her conversation. I would suggest that the police put those people under recess. This seems to be a conspiracy to disrupt the meeting. Oh, wait. No. Well, might as well. Well, just exclude them. The committee will resume. I'll just make one other observation rather than a question. This causes me misgivings because Secretary Stans testified before this committee that the treasurer of his committee disbursed in cash thousands of dollars to Liddy, that his treasurer remonstrated with the unwisdom of disbursing this money, and that at the suggestion of rather inspired with this remarks, that he went to and talked to Mitchell with it, and if it's quite possible that if Stans had gone before the grand jury, some inquisitive grand juror might have broke this whole story in July or August 1972, and this nation might have been spared the agony it's gone through since. Now, with reference to, I appreciate your commendation of, do you know whether Stans' attorneys were given a copy of the deposition?
No, I do not, sir.
I appreciate your commendation of the FBI investigation. A lot of innocent things sometimes impede an investigation. For example, this committee has information to the effect that the only question asked of Sloan, who had disbursed thousands of dollars of campaign funds in cash, was whether Baldwin, the man who bugged the Watergate from the Howard Johnson, was on the committee payroll.
I find that hard to I'm not saying that that's
Yes.
true and not true, but, you know, until Judge Sirica entered an order which compelled me and other officers of the Department of Justice from discussing this thing, and because of the political nature of it in '72, it was with great pride that I was publicly saying all over the United States the nature of our investigation. I think I refer to the fact that as of that time, in the middle of summer, before they went to the grand jury, 14,000 man-hours, 1,700 witnesses, 333 agents, 53 out of 59 field officers, some witnesses interrogated 2 and 3 times, practically everybody at the campaign committee, people at the White House. And I thought that was a remarkable achievement of the FBI. And I think the FBI is a great institution.
Well, I do too. I do too, but I think that maybe like Homer sometimes it might nod just a little bit.
Well,
I don't think, I know one thing.
they're human beings too.
From my long experience in the practice of law, that if you don't ask the right questions, you don't get the right answers.
But again, I think, Senator, and I'm not saying this to self-serve myself, but for the career people of the Federal Bureau of Investigation in a very, very unusual situation, I had nothing but pride and admiration for their professionalism and their constancy, and as I say, giving the Congress its due, giving the press its due, giving the judiciary and Judge Sirica its due. I'm sad to say that not enough has been given to the career people of my department and the FBI for what they did in this situation.
Well,
and I want to be here to make that testimony for them.
Well, I appreciate your loyalty to them, and I trust they're deserving of it. We do have testimony before this committee from Mr. Sloan that he told some of the prosecuting attorneys about the disbursement of this money to Liddy, and also about the fact that Magruder had attempted to persuade him to commit perjury rather than reveal the truth, and that he did that before the indictments were returned.
I didn't know that.
And we also, Mr. Ehrlichman, who expressed opinion on many points, he said that the reason that they did that, he thought, was because they decided that they would try the case in their own minds, and they decided that Magruder was telling the truth and Sloan was not.
Well, you know, when you have in our system of criminal justice, as you know, Senator Urban, you know, you have to have evidence to indict somebody. We don't put people on a rack and extract the truth out of them. We don't crush their fingernails or beat them over the head. And prosecutors, if they are responsible, they shouldn't, it seemed to me, on mere allegation and suspicion,
well, I'm not,
seek the indictment of somebody without evidence.
I'm just pointing out the fact that these facts did exist. I don't aver that to do that. Human errors of judgment sometimes impede us reaching the truth.
Sure.
And
sure.
I don't want you to think that any questions I've asked you or any observations I've made reflect or intended to reflect in any way on you. My contacts with you have impressed me with the fact that you're a rather forthright individual, and I think that this whole thing might have been avoided if some other people in the government had emulated your example when you told John Ehrlichman and John Dean there were certain things you wouldn't permit to be done.
Well, I'm a human being, and I make my mistakes and have my fallibilities, Senator Urban.
Senator Baker. Mr. Chairman, thank you very much. Mr. Kleindienst, reiterate what the chairman has just said. As a matter of fact, I had planned to call attention to what I believe to be a series of facts and circumstances to which you've testified or about which this committee has taken proof from other witnesses that seem impressive to me in the context of the questions I'm about to ask you. It appears that when on June 17th, 1972, you were approached on trying to get these Watergate burglars out of jail, you in fact said no, they're going to be treated like everybody else. Is that essentially correct?
Yes, sir.
And when John Dean asked for FBI files, you in effect said, if the president wants FBI files, let the president ask, but you're not going to get them. Is that right?
Yes, sir. Or anybody else.
And when John Ehrlichman called your people and complained and then called you to complain about the way certain matters were being held, you told John Ehrlichman, don't you talk to my people anymore. If you want to talk to me. Is that essentially correct?
Yes, sir.
And when you received information about the Ellsberg break-in, you found it to be of extraordinary importance, and you went to the President and talked to him about it.
Yes, sir.
And when on April 15th, 1973, the U.S. Attorney's Office and others came to you at the late hours of the night and laid out a detailed case of extraordinary involvement by White House officials, apparently, and by committee to re-elect officials, apparently, you promptly set up a meeting with the President. Is that right?
Yes, sir.
And you told the President about it?
Yes, sir.
And when you told the President about it, you wrote a note on the spot, virtually, saying that because of my personal and professional relationship with some of the people that may be charged with crimes, mentioning John Mitchell and others, that I recuse myself and require of Peterson that you assume these responsibilities and act as Attorney General. Is that right?
Yes, sir.
Well, on that basis, Mr. Kleindienst, I join in the chairman's statement. I think if more people had acted in that way, that the great trauma that we know as Watergate might very well not have happened or not continued, at least not into the cover-up phase. Now, let me move on then to two or three other things. The chairman and I joust from time to time about that grand jury appearance. And at the time the matter first came up, I confess I did not know there was legal precedent for taking proof outside the presence of the grand jury. And that precedent was brought to my attention. So as the chairman properly says, it's not illegal to take depositions and submit them to the grand jury. It then becomes just a matter of judgment, as distinguished from illegality. I still confess I'm surprised at that procedure and that precedent for it exists through the appellate courts. But nevertheless, I believe you've now indicated that in hindsight, and we're blessed with hindsight in this hearing, that in hindsight it might have been better to do it another way.
Let me clarify. That's one of the difficulties of being a prosecutor. You know, you have facts and circumstances at the time, and then in a proceeding such as this, and I think the chairman knows that I'm in hearty approval of these proceedings, or let's say a special prosecutor, they come back in and look over your shoulder and say, now, with all the facts before us, why did you use such bad judgment and did what you did? You know, that's the difficulty of being Henry Peterson or Dick Kleindienst or Earl Silbert, and having your conduct examined.
That's the penalty for being a United States Senator, too, and you look back and say, why did I vote the way I did on a particular measure sometimes? But
I've raised that question in my mind.
Well, I've raised that question in my mind about the Justice Department. So I guess we're about even. But what I'm really going to get into next will be the final preamble to the rather more detailed or rather more philosophical inquiry. I would like to know in greater detail about the conversation Mr. Thompson asked you about with the President about 1 o'clock in the afternoon on April 15th, 1973. By the way, I assume that conversation was taped if it was in the EOB office. Did you know those conversations were being taped?
No. Oh, I did not.
Have you ever asked for a copy of that tape?
Well, I've written a letter to Mr. Wilson, the attorney for Mr. Haldeman and Ehrlichman, making a demand upon them to furnish me copies of any tapes they have in their possession. And I've likewise written a letter to Mr. Garment to request copies of any tapes that they have in their possession between me, Mr. Ehrlichman, and Mr. Haldeman.
Have you had a reply to that?
No, sir, I have not.
Would you like to join us in our lawsuit? No. I withdraw that question. Could you did refer to notes, rather extensive notes that you took. Are those notes in your possession?
No, sir, they're not, and I've tried to find them for a hard-nosed 50-year-old geezer like myself. I was in kind of a state of shock from April 15th to April 29th, and I don't know what happened to them, Senator Baker.
All right, well, let's try to reconstruct it for a little while. And I hope somebody's keeping time on me because I don't want to run over 10 minutes. Rather than go through the detail twice, that is, once when it was told to you and you took notes, and the second time when you told the President, let's talk about what you told the President.
Well, I told him what I had written down on my notes.
All right,
and I took copious notes. Well, It was the summary of the statements made to me primarily by Mr. Silbert of what Mr. Magruder had been telling the prosecutors for a week and what Mr. Dean had been telling for a week. And it was with respect to particular individuals. The primary thrust of it was the efforts made by many to you use the term cover up, you know, and to obstruct the FBI investigation of the Watergate incident during the summer. It described these meetings from Magruder's point of view with Mr. Mitchell, the 3 meetings. Mr. Dean apparently was telling them information and conduct by him that was completely inconsistent with everything that Mr. Dean was telling me from June 17th up until, you know, shortly before April 14th. I don't pretend to remember it all.
Well, there are 2 or 3 important points. Let me try to reduce it to that. The information you received from the prosecutors on the early morning of the 15th of April 1973 essentially was a repeat of the Magruder and Dean testimony before the U.S. attorneys for the grand jury.
That's all it was.
All right. And in that, I assume from the testimony we received from Magruder and Dean, they were saying, in effect, that they didn't know about it, or let me think now. Dean, I guess, would have said he didn't know about it beforehand and began to suspect afterward and told the president, or rather assumed that the president knew something in September of 1972. I'm thinking the Dean testimony.
No,
did that item come out?
To the best of my recollection, the information given me by Mr. Silbert that night and the notes that I took did not in any way implicate the President of the United States.
Did you mention the September meeting?
I can't recall any specific dates, Senator Baker.
If you had to judge, would you say that there was any part of that conversation that said that the President knew or had reason to know of the alleged cover-up prior to March 1973?
Nothing was said to me that night that would implicate the President of the United States, to my recollection.
We have evidence that Mr. Dean talked to the President in March.
Well,
obviously the President knew something. I'm not quite sure what Mr. Dean told the President, but we have his testimony before.
I don't know either. Mr. Peterson, I understand, is going to be called to testify. He's had quite a traumatic experience in this tube. I don't think as intense as mine. He has a very good memory and recollection, and I think I would really rely or be willing to rely more on Henry's recollection of the information that he got before that meeting and what they gave me that night.
All right. Let's go to the meeting with the President then, if we depend on Mr. Peterson to tell us what he told you and elaborate that subject matter further with that witness. I must ask you, Mr. Kleindienst, a little more about the President's reaction. Particularly, did he give the appearance of a man who received information the first time, or one who had some familiarity with the subject?
Well, he gave me the impression of a person who either received it from me the first time or at least contemporaneous. And the reason why I put that qualification on it is as a result of Mr. Ehrlichman's telephone call to me the evening before at 5:30. And I would just, and I'm now speculating that based upon, you know, the proximity of Mr. Ehrlichman to the President, that if Magruder was up there in the White House Saturday afternoon telling them what he'd been telling the U.S. Attorney's Office, I've just got to believe that Mr. Ehrlichman called up the President and said, I've just talked to Magruder and I've got some very interesting information for you. But I know that the President's attitude and response to the information that I gave him was such that it was at least of a contemporaneous knowledge and one of well, he was just very upset about it, and he was very concerned about it, and he was very hurt by it, and he was very troubled by it.
Did he make any statements that he'd heard this from Dean before or hadn't? Or did he make any statements, this is the first time I ever heard this, or any statements to the effect that I'd wondered about it, but when you tell me, Dick, I believe it? I'm just trying to fantasize.
Not that I recall, Senator, and I was very upset that day. I know John Mitchell is one of the best friends I've ever had. I love him, I admire him, and it just broke my heart that his name was even mentioned in this thing, and the President was spending part of his time to help me with a personal situation. But I do not recall the President saying anything like that.
Well, I guess the summation then of your recollection is that the President gave the impression of receiving the information for the first time or having received much of the information shortly before your meeting with him.
Yes, sir. That's how I would interpret his conduct, what he said, his demeanor, and his attitudes.
And you've requested tapes of the copies of the tapes or the
I have not
opportunity to listen to
requested
those
copies
tapes?
of tapes of meetings that I had with the President of the United States. I have requested copies of tapes with Mr. Ehrlichman and Mr. Haldeman.
I believe I'll yield at this point, Mr. Chairman.
Senator Talmadge.
Mr. Kleindienst, why did you resign as Attorney General of the United States?
Well, it was just a combination of events, Senator Talmadge. I had to recuse myself on the morning of the afternoon of April 15th. I suppose the most pressing, important, significant matter before the Department of Justice as of that day was this Watergate situation, which meant that I, as the Attorney General, could not act as the Attorney General in our most significant matter. Then came the Ellsberg psychiatrist burglary. And then came the situation with respect to Mr. Gray and the documents that he received and subsequently destroyed. By the time those events had unfolded in my life, I really had arrived at the conclusion in my own mind that I could no longer function as the Attorney General of the United States. And here I am back at Burning Tree again, but that weekend prior to April 29th, they had a member-member golf tournament. And I remember talking to 4 people out there whose judgment I respect a great deal prior to Sunday morning, and told them of my decision. 3 agreed with it and 1 disagreed, the 1 being one of my senators from Arizona. I then had determined my own mind on the following day, Monday, to tell the President that I had to leave the office of Attorney General. It just was an impossible situation for me, Senator. And then around noon of that day, I got a call from the White House. The President wanted to see me. And I remember saying to myself and to them, 2 of these gentlemen, that I'm glad that I'm going to be able to see the President today. I didn't know what he wanted to see me about, and that I'd be able to give him my decision. And then that was the Sunday when he discussed with me the resignation of Mr. Haldeman, and Mr. Ehrlichman, and Mr. Dean, and the appointment of Attorney General Richardson.
Would it be fair then to summarize your resignation in saying that you had a feeling of unhappiness and frustration about the turn of events?
And then also, Senator Talmadge, you can't, I think from the standpoint of our fellow citizens, maintain an appearance that justice is being evenly and impartially administered when you have a person such as I, who is in the office, even though I recuse myself, and be involved in the investigation and the criminal justice process with respect to men like Mr. Mitchell and Mr. Mardian, and the proximity that I had with them, and have names like Mr. Haldeman and Mr. Ehrlichman and Mr. Dean, Mr. LaRue, and other men with whom I'd had a very close, intimate relationship for some 4.5 years. It just seemed to me that just from the standpoint of the administration of criminal justice in the United States, that Richard Kleindienst should no longer be the Attorney General, and it was the saddest realization I've ever had to make in my life.
There's one other thing I don't understand, Mr. Kleindienst, and Senator Baker touched on it. You indicated in your conversations with the President of the United States, when you informed him of events that you discovered from the Assistant Attorney General of the United States testimony in the grand jury room, an element of surprise by the President of the United States and perhaps a previous lack of knowledge about those events. Yet the President's statement himself that he issued indicated startling new information was discovered on March 21st. Now, your conversation with the President was some 3 weeks subsequent thereto.
Yes.
Apparently, the President had had previous startling information. Do you have any idea what that was?
No, sir.
Would you testify again that, to the best of your knowledge, and of course you're a skilled lawyer, that the President, at the time he talked with you, indicated no previous knowledge whatever of that subject matter?
Senator, he might have said something to me going back to March 21. I have no recollection of it. And I don't think that I would be a reliable person with respect to precise recollection on the events that occurred on April 15th. I was up all night. I went to bed at 5. I didn't get any sleep. I got up out of bed at 8:30. And I don't think I would trust myself as a precise witness on the events of that day.
There's one other thing you may want to comment on, and this is this famous tape conversation that Ehrlichman made of you. And you quoted in there, is Sirica is really lousing this thing up. What did you mean by that?
I had to call Senator Weicker and Judge Sirica the day after this amazing document hit the streets. Judge Sirica is one of the fine federal judges in the United States. He and I are close personal friends. I have nothing but the highest estimation for him. Also, as a lawyer, Senator Talmadge, I have never publicly ever said a critical or derogatory thing about a judge in my life. What I meant by that statement was that as a result of the sentencing procedures of Judge Sirica, and I think that lawyers could argue, as to the propriety of it, and there's a means by which you test that out in an appeal, not in public statements. It prevented us from getting Liddy, Hunt, and the other 5 back before a grand jury after their conviction and sentencing immediately to interrogate them under immunity to find out what they knew. They did not testify at their own trials. And it's a standard procedure of the Department of Justice, Senator Talmadge, as your prosecutors everywhere. If you have a conspiracy type situation, when you've convicted a person or persons and they're sentenced, then you bring them back before a grand jury, you put them under oath, and you give them immunity, and then you say, now tell us everything you know. And if they refuse to do so, they can be punished, for contempt. That's what we wanted to do. Judge Sirica, as a result of his sentencing procedures, and I know Judge Sirica believes firmly, because he's a firm believer, that he was doing the right thing. It just didn't suit our purposes at the Department of Justice. We wanted to get at Liddy and Hunt and the rest of them immediately.
And one final thing. I believe you testified that you had written Mr. Garment, counsel to the President, requesting a copy of the tapes that Mr. Ehrlichman made of you.
Yes, sir.
In your conversation. Has your view of executive privilege changed since you testified before congressional committees on April the 10th, 1973?
Easy, Mr. Chairman. From the standpoint of the law and the Constitution, my opinions as a lawyer have not changed. And I was rather flattered that Attorney General Richardson, who I think is a much better lawyer than I, came up with essentially the same opinions. From the standpoint of policy, and I never got around to my second round, Senator Talmadge. My first testimony was as a lawyer talking about the Constitution, and then I was prepared the next week to go up there on behalf of the administration and discuss the policy with respect to executive privilege. As a matter of constitutional concept, it's exactly what it was then. From the standpoint of policy, I think executive privilege should be used very sparingly, as it has been throughout history.
You don't believe that evidence of a cover-up of a crime would come under the purview of executive privilege, do you?
Senator Talmadge, if the President of the United States wants to exercise, based upon the doctrine of the separation of powers, a privilege not to give to the judiciary or to the Congress of the United States any document in his possession, I think under the Constitution, that is his constitutional right.
Even if it's evidence of a crime not
Yes,
related in any way whatever to the performance of his duty in office?
Yes, sir. That is my opinion. I said that several months ago.
Didn't you write a memorandum different from that at one time? I thought I had read it on one occasion.
Oh, gee, if I did.
I thought I saw a memorandum that you stated on one occasion where if the president could prevent a witness from appearing before a committee, that he could protect all of the several million federal employees in the performance of their duty.
Well, the only memorandum I know I wrote was the testimony that I gave before the United States Senate, and that was prepared testimony that I read. I'm not familiar with any other memorandum that I wrote myself, Senator Talmadge, and that document is before the United States Senate, that document and my testimony.
And you would state again that no matter how heinous crime may be, the evidence of that is in the president's possession, had nothing related, no way related whatever to the performance of a governmental duty, it would still come under the doctrine of executive privilege?
Well, under my understanding of the Constitution and the law, and incidentally, there aren't any cases in this area. I think the last case of the Supreme Court was, I think, around 1830, having to do with a post office contract. There just isn't any legal literature on the subject matter, Senator Talmadge, and the reason why there isn't is that this, throughout the decades, has been a political matter, you know.
So your conclusion is based on a judgment rather than judicial interpretation?
My understanding of an interpretation of the Constitution of the United States, a document that I revere with very much.
I'm certain that you do, but I don't see how a government can function if we take the position that each of the three separate branches of government are a government unto themselves and not subject to the system of checks and balances that must be applied to all.
Yeah. Well, I think as a result of events and circumstances, and when I read the newspaper, that question might soon be answered for us, Senator Talmadge, by the judiciary, you know.
Thank you very much, Mr. Kleindienst. I have no further questions.
Thank you, Senator Talmadge.
Senator Gardner.
Mr. Kleindienst, some of the people in the White House who've been before us as witnesses were not too happy about the appointment of this committee. As a matter of fact, they were rather concerned and nervous about it. You had a reaction. What was your reaction?
Well, I think my reaction was this. I think under our Constitution, with its great protections for individuals who are accused of crimes, that first you should prosecute somebody under the law so that they are guaranteed their rights under the Constitution and they can get a fair trial. And I think I'm now an individual, I'm not an officer of the United States government, and many might disagree with my opinion. I think I would have preferred to have permitted the Department of Justice to go ahead and prosecute everybody based upon the evidence. And then I've always said that there is an appropriate forum for the Congress of the United States to publicly go into and examine the conduct of public officials. Now, it's said that the public's right to know is more important than whether or not 2 or 3 people are prosecuted. My personal feeling is that the public's right to know should not be paramount to safeguards specifically inserted in the Constitution of the United States for the protection of an individual. Because the essence of our Constitution is that it seeks to protect individuals and not society, you know. And I guess we could all debate this. But I have never uttered a word in my life that the Congress of the United States or the Senate of the United States should not ever be vigilant and available to examine the conduct of public officials and the exercise of their public trust.
Well, that was my recollection.
Yes, sir.
Setting the timing aside of when we would hear them and when the prosecutors would examine them and prosecute.
Yes, sir.
as I recall, you publicly stated that this was probably a good forum and a healthy thing for the political side of the country to inform the public.
We're consumed now, it seems to me, Senator Gurney, with the negative aspect of Watergate, and very few people, it seems to me, take time to, write about the triumphs, of this situation. The triumphs are many. It proves to us that the institutions of freedom in this country are vital and that they are at work. People say that we don't have freedom of the press. We've got the most free press in the world. Our criminal justice system works. Our judiciary works. The Congress works. And then also out of all of this, and I've been a citizen politician for many years, I think as a result of these tragic revelations, that voluntarily politicians and office holders in this country for decades are going to have imposed upon them a higher standard of conduct than they ever have had before. I don't think any candidate running for any high office in this country is ever again going to want to say, well, you're involved in a Watergate situation. You can't legislate morality. You can't legislate men's hearts. And I think that really the decades ahead for my children, my grandchildren, is going to show and demonstrate a much higher level of conduct in American politics. And that's a great achievement for America.
Well, I couldn't agree with you more. I think you're absolutely right. I think it will have a ventilating and a cleansing effect, and I think politics and government will be the better for it.
And some people have despair, but our country is so great and so strong that the idiocy of a few people, can't shake the foundations of this great society and this great democracy.
On that same subject of good and bad, put it that way, I'd like to examine into this FBI thing a little more, because I think the FBI has been a great institution in this country. And
still is.
Still is, and from the evidence and testimony I've heard, I think they did a pretty thorough job, but I'd like to examine one or two little aspects of perhaps why they weren't able to come a little closer to finding out some of the broader implications. For one thing, when FBI people interview, they do it on a voluntary basis, don't they? And they can't swear a witness. They simply go and interview him.
And also, if somebody is a putative defendant, he has the right to take the Fifth Amendment and not talk to
That's right. He doesn't even have to meet with them if he doesn't want to.
And also, if people lie to the FBI, unless you have some evidence brought forth by somebody else, because of our protections of due process, the FBI doesn't get the guy slammed against the wall and crack him between the teeth and say, now tell me the truth. We prohibit that kind of interrogation.
The problem, I guess, was that there was a cover-up, and people weren't advancing information.
I've arrived at that conclusion, Senator Gurney, along with a lot of other
I think that's what we found here in these many weeks.
Yes, sir.
One question on that meeting with the President, I'm not sure that it was covered.
What meeting is that, sir?
This is the April the 15th Sunday meeting.
Yes, sir.
Did the President did he tell you in the meeting what he had been advised previously by John Dean?
No, sir.
That was
not to my recollection.
Not discussed?
No, sir. I was more interested in telling him what I knew and then dealing with the consequences of that knowledge on my part, my own deep feelings and what to do next. The decision to, my recommendation to have Henry Peterson, act in my place instead, getting Henry. Henry was working on his boat and came in with his first meeting with the President with tennis shoes and a dirty T-shirt, very embarrassed, going back to my department, executing the document by which I recused myself, and then going home.
Your logs show a number of phone calls and meetings during this period of time from the June 17th break-in until, well, through almost your resignation. Phone calls with Colson, for example. Did those cover Watergate at all?
Never recalled ever talking about Watergate with Mr. Colson.
There are also a number of telephone conversations with Mr. LaRue. Did you ever discuss Watergate with him?
Never.
And also one or two with Haldeman. Did you discuss Watergate with him?
Never.
There were a few phone calls with Mr. Krogh. What were they the subject of?
I think, and that was brought to my attention by Mr. Hare of the committee yesterday, that I had some conversations with Mr. Krogh on Monday, the day before the general election. I think you'll also see on that day there must have been 60 or 70 calls. I had meetings with Mr. Colburn, who was Director of the United States Marshal Service, and Chief Wilson of the Metropolitan District Police. Those conversations had to be with respect to problems involving demonstrators in anticipation of the election returns the next day. And Mr. Krogh, one of his assignments was to coordinate on behalf of the White House, the District of Columbia Department of Justice in this situation. Nothing with respect to this situation, Dr. Ellsberg, or anything else. I never heard of the so-called plumbers until it became publicly revealed.
Did the President at any time during all this period of time instruct you to go soft or slow upon this FBI investigation?
Never, at any time.
One thing about these affairs is that some people get brushed with tar when I don't think that's probably a fair thing. I must say, as far as you're concerned, and I think this is a good time to bring it out, that when you departed, you were lumped with Haldeman, Ehrlichman, and Dean. And I thought this was most unfortunate myself, because actually you were not in their class, I guess we might put it that way, in any respect. Do you want to comment on that?
No, the President asked me whether I would consent to have my name mentioned that following night. I did, and I would prefer not to make any other comment about it.
But in any event, your resignation was your own decision, and you were the one who suggested to the President that you resign.
Yes, sir.
Thank you. So,
Senator Inouye.
The taping of conversations is a subject explored by Senator Inouye when we return to the hearings. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Senator Inouye of Hawaii now asked Kleindienst about some taped telephone conversations.
Thank you very much. Mr. Kleindienst.
Yes, sir.
In response to a question relating to the famous conversation you had with Mr. Ehrlichman, which was electronically recorded, I believe you said that you just couldn't find the appropriate words to describe this, but you used two words, that it was reprehensible and unethical. Now, was it reprehensible because Mr. Ehrlichman could make self-serving statements, whereas you, not knowing that this was being recorded, would make statements which
I think
my
attitude is a little bit more subjective than that, Senator. I have never taped a telephone call in my life. I've never had it transcribed or written down. I think on a couple of occasions since I was in the department, because of an unusual call, I had my secretary make notes on another line, and that was a very unusual situation. But when you are dealing in good faith with people who you regard with trust and confidence, who are with you discharging a mutual obligation and undertaking, in this case on behalf of the President of the United States, to me it's the grossest breach of good faith imaginable for one person to make a tape recording that conversation without telling the other person. And if I had suspected that Mr. Ehrlichman was doing that without telling me, I would never speak to him again.
On April the 15th at about 1 p.m., you've testified that you had a meeting with the President to advise him of the conversation you had at your home early that morning.
Yes, sir.
Where was this meeting held, sir?
In my home?
No, I mean with the President.
Oh, in his office in the Executive Office building.
Were you aware that this office was electronically wired to
No, sir.
tape your conversation?
No, I don't have the same feeling about the President of the United States.
You didn't consider that reprehensible?
Well, I don't. If I was ever president of the Chamber of Commerce, I wouldn't do it. I'll never be president of the United States. I don't like it. I was surprised to learn of it. I think I was in Europe a couple of weeks ago when I heard of it, and I gave one of my characteristic attitudinal responses. I don't personally like it, but I do distinguish between a president and somebody like Mr. Ehrlichman talking to me, both of us who are working on behalf of the president when our business was for the president of the United States.
Then you had another conversation later that month, at which time you advised the president of the break-in into Dr. Fielding's office. Where was this meeting held?
That was likewise in his office at the Executive Office building.
And you were not aware that this
No, sir.
conversation was recorded?
I did not know that any conversation that I had with the President of the United States was recorded until a couple of weeks ago when I was in Europe on business.
In July of 1972, you've testified that you received a call from Mr. Ehrlichman relating to Secretary Stanz's appearance before the grand jury. And you've testified that you felt that Mr. Ehrlichman was involved in an act constituting obstruction of justice. I believe you used these three words.
It could have been construed as that. I think my attitude then was that Mr. Ehrlichman and I had to feel then he was pressed with burdens that the President or imposed upon him or he imposed upon himself. He had no background or experience in the criminal law. I just thought it was kind of a stupid mistake that he made. And I was more concerned, Senator, to have a very precise, clear understanding with Mr. Ehrlichman that that would not happen again in the future.
Didn't you think this was important enough for your reporting to the President personally?
No. He treated it lightly at the end, said, don't worry about it, it won't happen again. I called the President of the United States very seldom in my 4.5 years in the government. I tried to not impose myself upon him or insinuate myself upon him. I was prepared, however, to request a meeting immediately with the President if Mr. Ehrlichman had persisted in his original attitude that he would feel free to do this. Because I said to John, I said, then I'll come down and we'll meet with the President, and if the President tells me that you'll have that authority, then I will submit my resignation as Attorney General of the United States. It was not necessary for me to have that meeting, Senator.
Mr. Ehrlichman, you've testified that when you first learned about the break-in, I believe from Mr. Peterson,
Yes, sir.
Mr. Kleindienst, I'm sorry.
Yes, sir.
Yeah.
I'm flattered by the mistake, Senator.
You testified that your reaction was one of shock, and you considered...
On the break-in?
Yes.
On Mr. Peterson's call to me? No, because he didn't know much about it at 8 o'clock on Saturday morning, June 17th. The one that shocked me was Mr. Liddy coming out. I recollect saying that Mr. Mitchell told him to come out and fill me in, you know. The thing that shocked me was his fantastic statement that maybe people who were employed by the White House or the campaign committee were involved or were arrested last night. That floored me.
Mr. Liddy was known to you. You worked with him on Operation Intercept. He was a member of the Justice Department, and I'm certainly aware that he was counsel to the committee to re-elect the President.
I did not know that latter, sir. But my association with Mr. Liddy was very minimal and very brief as I described in 1969, and I don't believe I ever ran into him or ever saw him again until that
He
moment.
must have had some standing with you, because I doubt if you would have responded to someone saying, "Come here, come here."
Well, I knew him, Senator, and Mr. Moore, who did have standing with me, was with him. Mr. Moore and I were directly associated together in the Department of Justice when he was the Deputy Director of our Public Information Office.
Realizing the explosive potential of this break-in, because the break-in involved the headquarters of an opposition political party, didn't you feel it was important enough to directly advise the President of this conversation with Mr. Leader?
Well, I don't think I would advise the President. The investigation got underway immediately, and it was known within hours or shortly thereafter, days, essentially what Mr. Liddy told me, that is to say, and I think the first, I think Mr. McCord was identified almost immediately after they got rid of the aliases, and he was further identified as being employed by the campaign committee. That became public knowledge almost immediately thereafter, Senator.
My final question for this round, sir. In July of 1972, Mr. Baldwin, do you recall Mr. Baldwin, who was involved in the break-in?
I know the name, that's all.
Cooperated with the prosecutors and advised them that 2 phones in the headquarters of the party had been bugged, one belonging to Mr. Larry O'Brien and the other to Mr. Spencer Oliver. Were you aware of this, sir?
I don't recollect whether I was or not, whether Mr. Peterson told me there or not.
Well, for some unknown reason, when the FBI went through the complex, the headquarters complex, they just removed one bug, the one in Mr. Larry O'Brien's, and did not remove the one in Mr. Spencer Oliver's. Were you aware of this, sir?
No, sir.
Now, on September the 13th, the Democratic National Committee requested the phone company to sweep that area to have another look at it, and at that time they came across this bug in Mr. Oliver's.
In a phone?
Yes, phone. Were you aware of this, sir?
Oh, gee, I might have been aware of it, Senator. I have no present recollection of it.
And after that, the FBI conducted a very intensive investigation. They interviewed 80 members of the McGovern Campaign Committee and the Democratic National Committee. Weren't the FBI people aware of Mr. Baldwin's advice to the prosecutors that there were 2 bugs?
I don't know. I think Mr. Peterson might have better knowledge of that, or the FBI itself. I don't know.
I've just been notified that my time is up. I thank you.
Thank you, Senator Noya.
Senator Weicker.
Listen, you didn't take a swing at me, and I'm not going to take a swing at you. No, I wanted to add to Senator Baker's comments earlier, where he cited those instances where you had tried to live up to the spirit of the job which you held, both in what you did and in the way you related to others. I just wanted to add to that list the fact that when importuned to take a swing at the junior senator from Connecticut, you told him you wouldn't do it.
Well, I was trying to talk him out of it, and Senator, I was trying to use vernacular and suggestive language that would be calculated to talk him out of it. And that's why I might have used some language that I did. I'm not trying to ingratiate myself. You and I have had a very warm, friendly relationship, Senator, and I have a high regard for you.
Thank you very much. And I've already expressed myself on that point. Let me get to some facts here which I think might be helpful to our investigation. In the statement of April the 30th, 1973 by the President stated, as a result on March 21, I personally assumed the responsibility for coordinating intensive new inquiries into the matter. And I personally ordered those conducting the investigations to get all the facts and to report them directly to me right here in this office. Did you receive such orders from the President of the United States on March the 21st?
I have no recollection of talking to the President about that. I might have, but I don't recollect it, Senator Weicker.
Well, I should think that would be a pretty significant event, as obviously the language of the President in the statement is very strong. Those conducting the investigations to get all the facts, to report them directly to me right here in this office. I imagine if you receive such an instruction, it would come to your recall now.
I have no recollection of that.
Now, Mr. Kleindienst, I can't, unfortunately, leave your resignation at the point where you indicated to this committee that you preferred not to comment.
Yeah,
I too, in addition to, I believe it was Senator Gurney, found it rather strange to have you lumped in here in this same statement, I might add, with Messrs. Haldeman, Ehrlichman, Dean. And so I am going to ask you the question as to whether or not this matter was not discussed with the President prior to this April 30th statement, whether or not, and I'll just get them all on the table and let you answer them in your own way, you preferred to announce your own resignation, whether or not the President prevailed upon you not to announce your own resignation, but to be lumped in with this group.
Well, I think the President and I had, by different routes, arrived at about the same conclusion. Obviously we had, because Mr. Richardson was up at Camp David that afternoon, and I think the President had made the decision himself that he had to get another Attorney General. I had arrived at it independently. The President discussed specifically with me the fact that he wanted to announce my resignation the next day, and he asked me to permit him to do so. I consented, and I would prefer not to comment further about it. I've had a lot of great things in my life, and I've had some unpleasant things, and that's just all part of life.
I know, Mr. Kleindienst, but I think it is important to this committee to understand exactly what transpired in that instance. Did you want to resign yourself and make your own announcement?
Well, I informed the President when I first got up there that I had arrived at the soulful conclusion that I had to leave. And I think the President rejoined by saying, I think you're right. A couple of months before, our conversation was that he wanted me to be sure and stay past September when I left. I think one of the things he said, I got to have a whole Attorney General. I can't have half an Attorney General. And then came the conversation with respect to the manner in which it was going to be done. He asked me personally if I would permit him to do it then, and he wanted to be able to announce the change in the government and Mr. Richardson's appointment. And I consented to that.
In other words, it was his desire that you be put into this group. It was not your desire.
He asked me to permit him to announce my resignation then, and I consented to it, Senator.
I still have to ask the question, why you were not permitted to go ahead and announce your own resignation?
Because the President asked me to permit him to do it that Monday night.
When you first arrived at Camp David, did you want to announce your own resignation?
Yes, sir, I had, and so informed him before our conversation started.
And so it was at the importuning of the President, you did not announce your own resignation, but rather went along with his request to be put into this group. Is that correct?
Well, he's the President of the United States. I was serving him. He asked me to do it. I did.
I'd like to, if I could, ask a few random questions until my time expires. The sequence, insofar as Mr. Gray is concerned, April the 5th, he withdraws his name for consideration before the Senate. Is that correct?
Yes, sir. I believe that's the date, April 5th.
And I believe also at that time you wrote a very warm personal note of appreciation to Pat.
I have the highest regard for Pat Gray. I think he's one of the finest men I've ever known in my life, and I feel very sorry for him.
Now, on April 27th, following the conversations in your office on the 26th, he steps down.
Yes, sir.
Now, what transpired in the meantime here, or more specifically, at what point did you become aware that apparently both the President and certainly Mr. Ehrlichman and Mr. Dean had come to the conclusion that Pat Gray would not be a man for the directorship of the FBI?
Well, you have to distinguish between, I guess, the events that occurred after April 5th, when it was, I think, indicated sometime around that time, and before April 15th, Mr. Gray's nomination had been withdrawn from the Senate. And then after April 15th and before April 30th, I had a meeting with Mr. Gray and Mr. Peterson in my office in the middle evening around 8 or 8:30, and the next day he then resigned as the acting director of the FBI. I don't know when I learned of the decision that Mr. Gray's name would be withdrawn from the Senate to be the permanent director. I'm sure I would have known about it around the time.
Around what time?
Well, the time that it was withdrawn. His nomination was withdrawn.
You know that we have testimony, Ms. Kleindienst, before this committee that would indicate that both Mr. Ehrlichman and the President had soured on Pat Gray in around March the 6th or March the 7th.
Yeah, I didn't know about that. I know, I guess, as of the time I was out in San Clemente around April 5th, that I must have known that the decision was made because we were talking about my recommendations for a person for the President to nominate to be the next permanent director. So I guess I knew about it prior to April 5th. I don't believe I was informed that day of the decision. I think I probably knew that before.
Now, in testimony yesterday, Mr. Gray indicated to the committee, I think I'm correct in my paraphrase, that when they met in your office on the evening of the 26th, that you advised Mr. Gray that you thought it best that he step down.
Yes, I did, and Pat really didn't agree with that. I called the President, gave him a report of our meeting, what Pat told me. I said, Mr. President, my recommendation is that Pat step down. Pat doesn't feel that way about it. And then my recollection is, Senator, I read Pat's testimony yesterday, but my recollection was that I said, Pat, tomorrow you have a meeting with the top people of the FBI and get their reaction as to whether or not, as a result of this situation, you can credibly serve as the acting director until a permanent director comes along. He seems to recall it that was his own thing. Maybe not, I don't know. In any event, the next morning he did meet with the top people of the FBI, and he called me and said that, and I recall it saying that you're right, you know, the people here do not feel that I can credibly remain as the acting director,
And then I recall that I said, well, Pat, I think that you ought to call the president yourself and submit your resignation to him this morning, and you do that directly. Now, that's my recollection of it.
I have
Incidentally,
no
Senator
dispute with that recollection, but may I just ask one question? I don't want to interrupt you, please.
Well, I want to set the record straight on one thing. You recall Mr. Gray had made an offer to the members of the United States Senate that they could have access to the FBI files, and then that order was rescinded. I believe that you were scheduled to go up there on a Saturday morning to see them.
That's correct.
And that I called you personally and said that I had ordered that to be rescinded. No one else was responsible for that decision except myself. I disagreed with the position taken by Mr. Gray in his confirmation hearings, and that I was the one, as the Attorney General of the United States, who rescinded that offer by Mr. Gray. And I think I called you personally, and it wasn't a pleasant task for me to call you personally that I had rescinded it. And I think there was something said yesterday to the effect that somebody else had made that decision. Nobody else did. I made that, and I want to take that responsibility.
The last question, as my time is up. When you called the president, did the president tell you that Pat Gray should step down on the evening of the 26th?
No, I think I gave him my recommendation, and I also, to the best of my ability, reported Pat Gray's position on it. And I think the president then said to me, well, if Pat doesn't want to resign, immediately or right now, I'm not going to require him to do so until we can analyze the matter further or get some additional information. That was the president's posture.
Thank you, Mr. Klein. My time's up.
Senator Montoya.
Mr. Kleindienst.
Yes, sir.
About how many times did you speak to the president between June 17th and the time of your resignation?
How many times?
Yes.
Boy, it would be a guess. The committee has in its possession my telephone logs that would more accurately reflect that. I would say 10 or under times, and that's just a guess, Senator Montoya.
10?
10 or under, and that's a guess on my part.
How many times did you visit with him at the White House during this time?
That's from June 17th, the Watergate situation, Senator?
Yes.
I don't believe, although I could be mistaken, that I visited with him after June 17th at the White House until I returned from Europe after the election, and then I had 2 meetings with him at Camp David.
Were those the only 2 meetings, either at the White House or Camp David?
To the best of my recollection, sir. And I could be wrong, and again, my appointment book or my logs would be the best evidence of that.
Did you, during those meetings or during those telephone conversations, discuss Watergate with the president?
Well, in a very broad way. I didn't know much about it. I was in charge of the investigation. I had confidence in it. I would have indicated to him what I was doing, what the FBI and the criminal division and the prosecutors were doing, generally.
Did you discuss with him the possibility that some members of the White House or the CRP might be involved?
I had no basis for such a discussion. I had no evidence of that, of any credible nature until April 15th, 1973.
Did he ever ask you any questions as to whether, from the evidence or state of the evidence that you had, there might be some involvement by personnel from the White House?
Not that I recall, because Senator Montoya, if I had come into possession of evidence of that kind, I like to think, and I am confident of the fact, that I would have informed him immediately.
Who would the president go to for an investigation of this type? Would he go to the Department of Justice?
Well, the Department of Justice, through the FBI and the U.S. Attorney's Office, had a prodigious investigation interrogating all kinds of people up there. I think by the time on or about March came along, Senator Montoya, instead of 1,700 people being interviewed, the interviews had gone up to 25, 26, or 2,700 people.
Well, who was actually in charge of all this investigation? The Department of Justice?
Yes, sir. The FBI, the Criminal Division, and the U.S. Attorney's Office.
And would that be you as the head of the Department of Justice and those working under you?
Yes, sir.
And do you have any knowledge whether or not the President talked to Mr. Peterson about this investigation at any time?
I am almost positive that Henry Peterson never talked to the President of the United States until Sunday, April 15th, 1973.
Then I will read to you, give your answers, the statements contained in the President's address of April 30th, 1973. Last June 17th, while I was in Florida trying to get a few days' rest after my visit to Moscow, I first learned from the news reports of the Watergate break-in. I was appalled at this senseless, illegal action, and I was shocked to learn that employees of the Re-election Committee were apparently among those guilty. Here he says, I immediately ordered an investigation by appropriate government authorities. Now, he did not talk to you about this, so apparently the President was wrong in this statement. Well, let me read further. As the investigations went forward, I repeatedly asked those conducting the investigation whether there was any reason to believe that members of my administration were in any way involved. I received repeated assurances that there were not. Then...
May I comment right there, please?
Yes.
I think that is a fair statement for the President to make, because John Dean was over in my office on the Monday, found the break-in and was there quite continuously, and his purpose in being there, according to his representation, was to get general information from me and Mr. Peterson. And I think it would be logical that Mr. Dean was going back and reporting, I thought, to the President. I don't know if he was or not, but at least to Mr. Ehrlichman or Mr. Hall.
Well, he said, I repeatedly asked those conducting the investigation. Mr. Dean was not conducting the investigation.
Well,
then...
right there, Senator Montoya, I don't believe I talked to the President on Saturday, June 17th. I might have, but I know I talked to him sometime immediately thereafter, and my conversation with him and the direction he gave me, he didn't have to say, now, Kleindienst, you've got to go out there and investigate this. I think I understood what my duty was, but there was no doubt in my mind as to what the President wanted to have done in this thing. If he didn't want to have it done, I don't think I would have been there.
Well, why would the President couch his statement in these specific terms?
I don't know.
All right, now, let me read the next
comments that I've made.
Let me read the next paragraph. As a result, on March 21st, I personally assumed the responsibility for coordinating intensive new inquiries into the matter. And I personally ordered those conducting the investigation to get all the facts and to report them directly to me right here in this office. Now, if you state that the President never talked to you about this, and to your knowledge, he did not talk to anyone in the Department of Justice, could it be possible that he was talking to the United States District Attorney downtown?
No, I construe that statement as of March 21, Senator Montoya, to mean that he was having, as I learned subsequently, Mr. Ehrlichman to conduct an in-house investigation. That's based upon what Mr. Ehrlichman told me Saturday evening, April 14. That's what I would assume the investigation was an in-house, non-Department of Justice investigation.
Well, Mr. Ehrlichman testified that there was really no investigation going on his part, And Mr. Dean has also indicated that he was just going around trying to find out what was being done, that's all. But the actual investigation was being conducted by the Department of Justice.
Yeah, we never stopped our investigation. At no time did the Department of Justice ever consider that the Watergate case was closed.
Now, did it ever occur to you that you might visit the President and inform him as to what you might be reading in the newspapers and what curiosity was being aroused in your mind as to possible implication on the part of people at the White House or at the committee to re-elect the President?
I didn't have any reason to do that. There are people up there who read the newspapers and can brief the President on that.
Yes, but you were in charge of the federal investigation, and you were the Attorney General
Senator Montoya,
of the United States.
With God as my witness, not until the night of April 14th or between the hours of 1 and 5 o'clock in the morning in my home on Sunday, April 15th, was I ever given any credible evidence by anybody that would indicate the criminal culpability or complicity of any top White House or campaign people in this entire matter. As soon as I got that information, I immediately set in motion a meeting with the President of the United States.
You were being briefed quite constantly at the Department of Justice about the state of the investigation,
Yes,
were you
sir.
not?
Yes, sir.
And wasn't there any evidence indicating complicity on the part of people at the CRP?
No, sir.
During those briefings, any
No,
evidence brought to your attention?
No, sir. Henry Peterson and I speculated almost constantly, particularly after the trial and Judge Sirica's sentencing procedures, that it was just possible that Gordon Liddy or Mr. Hunt or one of the five, if we could get them before a grand jury, give them immunity and compel them to testify, could have evidence to offer that would involve somebody else. But I remember Henry Peterson saying to me, even after the McCord statement, that standing by itself with just hearsay and speculation and conjecture, that document itself did not provide evidence with respect to the guilt of anybody else.
I'll ask you one more question. When Mr. Ehrlichman was testifying before this committee, I asked him if the White House knew of the burglary of the Ellsberg psychiatrist's office on or about September 4th. Why didn't you tell the Department of Justice? And he indicated in his answer that information had been imparted to the Department of Justice.
That's absolutely untrue.
All right. Now, I have it here in the transcript. I have the transcript.
To my knowledge, that's untrue.
Yeah. Well, I have it here in the transcript, page 555. My questioning starts. Well, there is one thing. This is a question of Mr. Ehrlichman. Well, there is one thing that strikes my fancy, Mr. Ehrlichman, that the burglary was committed on September 3rd or 4th of 1971, that you knew about it a few days later upon your return from Cape Cod, that Mr. Liddy knew, that Mr. Krogh knew, and that presumably other people in the White House knew. Then why did it take them until April 15th, 1973, for the U.S. District Attorney here in the District of Columbia, Mr. Sealbert, to first find out of that burglary and then have to transmit that news to the Department of Justice?
Senator Montoya, the memorandum from Mr. Silbert to Mr. Peterson, dated Monday, April 16th, said that an unidentified source has informed us yesterday, Sunday, April 15th, about this situation. One of the things that Mr. Peterson told me was that unidentified source in the Silbert memorandum to him was John Dean. And John Dean is the one who told the prosecutors on Sunday evening, April 15th, about the Ellsberg break-in.
I'm not questioning your veracity. I'm just pointing out that perhaps Mr. Ehrlichman deceived this committee with that statement.
I don't want to comment on Mr. Ehrlichman's testimony. All I'm saying to you is that to my knowledge, the knowledge of Earl Silbert and Henry Peterson, and the responsible people of the Department of Justice, the first knowledge that we ever had of the break-in of Dr. Ellsberg, psychiatrist, was Sunday evening, April 15th.
Thank you, sir.
Thank you, sir.
I have no further questions. I think you've been rather thoroughly interrogated. I do have two observations, one of which will be no surprise to you, and that is I find myself incapable of accepting the theory that the President has a constitutional power to suppress testimony about criminal acts on the part of members of the executive branch of the government. I can't reconcile that notion with the very simple words of the second article, which say that which prescribe the President's duty in these words: "He shall take care that the laws be faithfully executed." Now, my other statement is I would like to, in fairness, state that during the time you were in the Attorney General's office and this committee was in existence, that you manifested a willingness to and desire to cooperate with this committee to the fullest possible extent.
Thank you, sir.
Senator Baker.
Mr. Chairman, thank you very much. I also do not have further questions. I might make, as I have previously, a remark of thanks to Mr. Kleindienst for his cooperation and for his testimony today. I think it's very helpful. And to say one word about the question of the scope and extent of the doctrine of executive privilege, I note with great interest the disagreement between the chairman and the witness on that subject, and they're both distinguished legal authorities. One, a former Attorney General of the United States.
One not as distinguished as the other.
One, a former Attorney General of the United States, and the other, the possessor of one of the original copies of the Constitution. But I might say that my father taught me that you can try to settle a lawsuit all your life, but the court finally decides.
That's why we have courts.
And that's one reason I'm glad we file suit. There may be a great quarrel about whether we have authority to sue or whether the President should or should not have to yield up these tapes under one of the other doctrine or theories that set out the litigation. But finally, unless the court ducks the issue, and I very fervently hope they do not, finally then the court will decide, and my distinguished chairman and my distinguished former Attorney General will not have to argue about that, because the law will be what the court says it is.
On the doctrine of separation of powers, that's going to be decided by the judiciary and not by the Senate or by the executive office.
It's like the young lawyer I mentioned earlier who was arguing a case before the Supreme Court. The Chief Justice said, "Young man, that's not the law." And the young fellow says, "Well, it was the law until Your Honor spoke."
I guess that's right.
Thank you.
Senator Talmadge. Senator on our way.
Thank you. I just have a few questions. Mr. Kleindienst, you're aware that Mr. Ehrlichman met with Judge Byrne while the judge was presiding over the Ellsberg case.
I learned that, yes, sir.
Did you think that this was highly improper?
Boy, I know that I, as the Attorney General of the United States, and as an officer of the Department of Justice that had a case before Judge Byrne, it would have been highly improper for us to have done it, and to have done it only through our prosecutor in the presence of the attorneys on the other side, regardless of what the situation was. Whether or not the same restrictions would apply to a person on behalf of the President of the United States, I'm doubtful, Senator Noyu, in all fairness to Mr. Ehrlichman, because the mission was very limited and very specific. It had nothing to do with the case. I think just generally speaking, because of the nature of the Ellsberg trial and the involvement of the administration and the Department of Justice and its controversy, it was, in my opinion, probably ill-advised, just because from the appearance, of the administration of justice. My knowledge of Judge Byrne, however, is such that I can't imagine a circumstance existing under which he would ever permit himself to be compromised or in any way interfere with the administration of his duty as a federal judge.
Was it highly improper to involve the President of the United States? Testimony shows that the President was brought into the conversation, even briefly.
I understand that the President just walked out and said hello and went back, and all I know about it is what occurred here in this hearing center, know you?
Canon 9 says a lawyer should avoid even the appearance of professional impropriety. A lawyer should promote public confidence in our system and in the legal profession. You don't think that this...
Well, Senator, I don't know, and I'm trying to be fair about this, I don't know whether what Mr. Ehrlichman did was as a lawyer, as an officer of the court. He wasn't representing the United States in that thing. He had nothing to do with the trial. I think I would prefer to characterize Mr. Ehrlichman's role there as an agent of the President of the United States pursuing an objective of the executive branch of the government. And I don't know if that canon would be applied to him in that situation.
In the hierarchy of the Justice Department, are you considered superior to Mr. L. Patrick Gray, the director of the FBI, Mr. Gray?
Well, I don't consider myself superior to anybody. I think Mr. Gray was under the authority and jurisdiction of the office of the Attorney General.
Were you in a position to direct him or to give him orders?
I believe so, and I have done so from time to time.
And did he have a responsibility to report to you, sir?
Oh, sure. But he also had responsibilities to discharge. I had nothing but the utmost confidence and trust in him. The department is a big one. It's got 50,000 employees, 17 divisions. I met with Pat Gray quite frequently. He attended our staff luncheon every Friday noon, and he also was a close friend of mine, Senator. He was going to be the Deputy Attorney General, and if and when I got confirmed as the Attorney General, then Director Hoover passed away, and I was in the forefront of those recommending Mr. Gray to be the permanent director and to succeed Mr. Hoover. So I've had nothing but the closest, finest relationship with Pat Gray, and he and I, we're kind of both stubborn people, but we never had a problem between us, and it was never a question of my ordering Pat Gray. We had a discussion, and I would make a recommendation, and I can't ever recall a recommendation in the discharge of his official duties of mine that he didn't follow.
Did Mr. Gray ever tell you about the instructions he received from Mr. Dean and Ehrlichman to destroy classified papers?
Yes, he did. He told me that on the evening of April 25th, the night before he withdrew as the acting director of the FBI.
He didn't tell you in the year 1972?
No, sir. That's the first time I had ever heard of that situation, was that night, Senator.
Do you think he should have told you as soon as he received those instructions?
Gosh, Pat Gray has lived a great life, a great patriot, and I think he made one mistake. I think it's going to burden him the rest of his life. Sure, he didn't, and that's an incident, and I would put that against his career of service and what I know about him as a man, and just say, well, here's a human being that made a mistake.
Were you aware, Mr. Kleindienst, of the attempt made by Mr. Dean to influence FBI investigations of Mr. Ogario and Mr.
No,
Dahlberg?
sir.
When did you learn of this, sir?
Well, most of that testimony vividly came to my attention. That's the CIA situation.
This is when Mr. Dean told Mr. Gray to stop the investigation on Mr. Ogario and Mr. Dahlberg. Mr. Dahlberg, as you know...
Senator Inouye, I might have been informed of that last summer, but I have no specific recollection of it. Mr. Peterson would have been the one who would have known about that if he thought there was a serious interference with the orderly work of the department. I know that Henry would have come to me, and I think I have an idea of what I might have said to John Dean.
inasmuch as that kind of an incident didn't occur, I don't think that I knew about it or it was regarded as a serious interference with our work.
As Attorney General, did you know Mr. Ken Kachigian?
Ken?
K-A-C-H-I-G-I-A-N.
Not that I don't believe so, Senator.
Mr. Haldeman had, in his testimony, said that Mr. Kachigian had prepared a report which indicated that demonstrations and other violent activities were carried out under the guidance of agents of the opposition party. Were you aware of that?
No. I was, for 4.5 years, responsible for the coordination of the efforts of the executive branch of the government regulating demonstrations and dissent, and probably had more information about it than anybody in the United States. I have never heard of that name, and I don't recall ever talking to Mr. Haldeman about it or ever getting a memorandum or a report from him.
As the person in charge of this investigation, were you aware of any involvement of the Democratic Party or the candidates, Mr. McGovern, Mr. Jackson, Mr. Humphrey,
I
Mr.
think
Muskie?
the only incident that I was ever aware of, there was the president during the campaign was to make an appearance in Los Angeles. And the reason why I became aware of it, I was out there speaking myself. As a matter of fact, I had a speech canceled because the president was going to be there. And I think in the McGovern headquarters in Los Angeles was used by some to organize a demonstration against the president's appearance in Los Angeles. I think that's the only incident that I was aware of.
Was this a violent demonstration involving...
I don't know. I think that there was quite a lot of preparations made, and I think that the president had to change his plan and arrive at the hotel by a helicopter as compared to what otherwise he wanted to do.
Other than that, you're not aware of any involvement?
I received no report of any arrests or anything like that, Senator Noyer.
I thank you very much, sir.
Thank you, sir.
Senator Garney.
I have no further questions, Mr. Chairman.
Senator Montoya.
I have no further questions, Mr. Chairman.
Senator Wyckoff.
Just two brief questions on the Ellsberg matter. When you notified the president of the break-in at Dr. Fielding's office, did he exhibit surprise at the information you gave to him?
Well, I know he was very provoked, Senator Weicker. I think we could have had a contest on which one of us, was the most irritated by it. I don't know whether I could testify whether he had had any prior knowledge of it. And it was not my habit to interrogate the President of the United States.
But did you have prior knowledge of the fact that since the inception of the Ellsberg matter that the President had taken a rather personal role in that?
No, sir. I never heard about the plumbers or...
I'm not talking about the plumbers. I'm talking
About the Ellsberg break-in?
No, not the Ellsberg break-in. The Ellsberg matter.
Oh, the lawsuit?
The entire matter, the lawsuit, from the matter from its inception.
I don't know. I might have discussed briefly with the President about the Ellsberg suit. I know I would have talked to Mr. Ehrlichman about, our position on the suit and our desire to do everything possible to convict Mr. Ellsberg of the crimes that we alleged in our complaint. But I never had anybody interfere with me in that.
I'm not talking about interference. I don't mean to give that impression.
I didn't need anybody to put me down the road on that lawsuit, and I don't recall having any conversation with the President about it.
Do you recall receiving a call from the President requesting a progress report on the Ellsberg case getting in touch with Mr. Mardian and then getting in touch with the President at Camp David?
Could have, but I don't recall that.
Now, do you think the President's surprise or his being provoked, I guess is the exact term that you used, at the information that you gave to him, do you think it was because the information was public or because of what had happened?
Oh, well, it's the manner in which he characterized the act itself. left it unmistakably clear to me that he had a very negative attitude about that conduct.
I have no further. Yes, just one comment I'd like to make, Mr. Chairman, because it was something that Mr. Kleindienst said, which I couldn't have agreed with more. I find it a little hard to reconcile with your definition of separation of powers, but I noted in your comments on our democracy how you stated that the emphasis of our democracy is to protect individuals rather than society.
To me, that's the foundation of our government and our Constitution.
I think it is too.
And distinguishes it from almost every other government in the world.
I think it is too, that the individual is important. Each one of us.
Each one of us.
Is important, far more important than society, and certainly there are none of us that are better than anyone else, if you will. And yet it seems to me that some of the things that went on in this period of time were done in the name of society, with the protection of the individual, sometimes being disregarded to a certain extent. And I wonder how you, for example, in this latest exchange here with the committee, equate this deep feeling that you have, and I feel exactly as you do on this point, with the fact that, in fact, if the President has information which could involve the, let's say, freedom of someone, such as the tapes might relate to the freedom of a particular individual, never mind the constitutional confrontation between the committee and the executive branch of government, information that might relate to the freedom of a particular individual, that he wouldn't be obliged under the Sixth Amendment of the Constitution to hand that information over. How do you relate those two?
I'm just a private individual now, Senator, and I haven't thought about my attitudes on that, and I would like to be excused from doing so right now.
I have no further questions,
Mr. Chairman, I've got to say I thought there for a minute that the witness was going to say he's just a country lawyer.
Well, as a matter of fact, that's all I am, Senator.
Mr. Kleindienst, do you recall an October 24th, 1972 meeting with Richard Helms at which certain records of the CIA were turned over to you?
Yes, sir, I do.
And what did you do with those records?
The day before, I believe, Ambassador Helms called me and said that Silbert had requested the CIA to supply some written information to it. He said, I have no objection to giving that to the United States Attorney's Office. However, I would like to deliver it to you personally so that you could pass the admonition to the U.S. Attorney's Office that some of the material could be, if it was revealed, could interfere with the mission of the CIA. He agreed to come into my office the next day. He came in with his general counsel. He had an envelope in his hand. As soon as he got there, I called Henry. Henry came up. I explained the situation to Henry. Henry took the envelope and left to go to his office with Mr. Houston, the general counsel of the CIA. Ambassador Helms, who he and I have a very warm, friendly relationship, stayed for a couple of minutes and chatted, and he left. And that's all I know about the incident.
Now, your records show a few contacts in early 1973 with Jeb Magruder. Do you recall what those were about?
Yes, sir. He was working for the Inauguration Committee. I intended to host at my home during the inauguration a party for everybody who was here from Arizona. And I was talking to Magruder throughout that period of time to get assistance and help from him to make that possible.
Do you recall attending a luncheon with Mr. Ehrlichman and Mr. Dean between the time of the conviction of the Watergate defendants and the time of their sentence at which the subject of possible leniency for the defendants came up?
I didn't when I talked to you or Mr. Harry yesterday. I talked to Mr. Peterson yesterday to see if he could recall anything. And I now remember that at a lunch that I had there, I think we had several matters to discuss. The question came up as to the procedures of sentencing. What happens? And Mr. Ehrlichman didn't have much of a knowledge of the criminal justice system. And I think they were just talking about what happens when somebody is convicted of a crime, how the sentence is
meted out? What is the probation report? What happens when you go to jail? When are you eligible for a pardon? When do the circumstances arise for executive pardon? And it was a technical procedural discussion that I had. No individual's name was mentioned at that time.
When Mr. Peterson came to you on the early morning hours of April 15th, I believe you indicated that no information was imparted to you that Dean could implicate the President of the United States. Is that correct?
That is correct.
Was there any explanation given as to whether Mr. Dean was holding back things or relying on executive privilege or anything of that nature?
I think that Mr. Silbert, to the extent that at least I believed at the time, that he gave me in summary form every bit of relevant information that he had obtained from Mr. Magruder and Mr. Dean. I believe that at the time.
When did you first learn that Patrick Gray had burned the Hunt file?
The night before he left the Federal Bureau of Investigation.
During the time you were Deputy Attorney General, were you aware of the nature of the political activity by Mr. Mitchell, including specifically any contacts he may have had with Mr. Liddy?
I was never aware he had any contact with Mr. Liddy. My custom when I was the Deputy Attorney General was to meet Mr. Mitchell at 9 o'clock and at 5 o'clock every day when we were both in town. Immediately prior to March 1, when Mr. Mitchell left, I recollect once or twice seeing Mr. Magruder in his office when I came up for my 5 o'clock meeting. When I arrived, Mr. Magruder would leave and I would have my 5 o'clock conference. And that's just about the extent of my knowledge with respect to Mr. Mitchell's association.
One final question, Mr. Kleindienst. While you were Attorney General, did you engage in any partisan political activity?
With the exception of one occasion after I was confirmed by the United States Senate and I went back to Phoenix, Arizona, when the Trunk and Tusk Club gave a dinner in my honor, and that's a Republican club. I have never attended a political meeting, a Republican Party meeting of any kind since I entered the Department of Justice on January 29, 1969.
I have no further questions, Mr. Chairman.
On behalf of the committee, I want to thank you for your cooperation and for your appearance here today. And as far as I know, you're excused from further attendance on the committee unless we notify you again.
Thank you, Senator. Thank you, gentlemen, for your courtesy.
The committee will stand in recess until 2 o'clock.
After the lunch recess, a new witness, Assistant Attorney General Henry Peterson, comes before the committee, and we'll have that testimony in just a moment. In the meantime, public television's coverage of the Senate Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service.